Please carry on the court.
Welcome to the court, Your Excellencies. Today, I, Mohammad Raisul Haq, is acting as court officer along with Mashur Rahman, acting as courtroom manager and timekeeper. Your Excellencies, may we start the court proceeding?
Yes, you may.
Much obliged. Prosecution counsels, are you ready?
Yes, ready.
Thank you. Defense counsels, are you ready?
Yes, we're
ready.
Thank you. Today, before the pre-trial chamber, the matter has been brought between the prosecutor versus Brigadier Xavier on the situation in the Republic of Zenzik. With permission of the court, the proceeding is being started now. The court is in session. Now, I'm inviting the prosecution counsels to present their case. Prosecution.
Am I audible?
You are, counsel. Proceed.
May it please the court?
Sorry, could you
Yes, if you may proceed. Much obliged, Your Excellency. Your Excellency, my name is Humanitarian and I, along with my co-counsel, Sanjida Hadarsima, are representing the prosecutor in the matter between prosecutor versus Brigadier Xavier. We are from team P0, it's in team 2026, Your Excellency. Your Excellency, before I begin my submission, I would like to say that the fundamental right to life is the most important part of a human being, Your Excellency. With that thing as a note, I would like to begin my submission on the first issue, which is whether the prosecutor should be given the permission to move from a preliminary examination to the investigation of Zenzik to an investigation. Your Excellency, in order to determine whether the prosecutor should be given the permission, the categories are defined in Article 53, paragraph 1, clause 8 to clause 3, clause 8 to clause 3 of the Joint Statute, Your Excellency. In that regard, Your Excellency, the prosecutor submits that the case passes the first test, which is the reasonable basis to proceed, to believe. Your Excellency, this case is based on the logical interpretation confined solely on the preliminary examination, where the evidence is neither comprehensive nor it is conclusive as compared to what we have gotten, what would have been obtained during the investigation, and the powers of the prosecutor are limited at this stage. At this stage, it is sufficient to prove that there is reasonable conclusion which can be supported on the basis of evidence and information, as was provided in the case of Ahmed Al-Rashid in paragraph number 36. Your Excellency, moving forward to the second element of the issue, whether the
Lord Counsel, what is the reasonable basis of bringing this case before the pre-trial chamber? What reasonable basis you are able to establish before us?
Your Excellency, in the fact paragraph number 13 to 14, it is clearly mentioned that the TPP report on human rights violations has noted that from 2011 to 2014, an estimated number of 12,000 people, 12,000 civilians, I might say, were killed. And there was destruction, burning of entire civilian properties, and displacement of large part of civilian population, which the prosecutor submits is a reasonable basis to proceed with this case, Your Excellency.
Counsel.
So they have
forward, Your Excellency.
Sorry, please proceed, Judge.
Much obliged, Your Excellency. Your Excellency, moving forward to the next element, whether the case passes the principle of complementarity. Your Excellency, following both the general international law and the statute, states are obliged to investigate, prosecute, and punish international court crimes. The burden of proof in this regard falls on the state to provide the court with sufficient evidence which has a certain degree of specificity and appropriate value that demonstrates that it has indeed investigated the case genuinely, as was mentioned in the Gaddafi case in paragraph number 52. Your Excellency, the goal of the Rome Statute is to put an end to the impunity where the state fails to investigate, the court must be able to step in, as was mentioned in the case of Francis et al. In paragraph number 40.
Learned Counsel, please. Learned counsel, please stop. Court manager, please stop counting your time, because I think Nicole has some problem in hearing the submission.
Oh, no, it's okay. I can
It's
hear.
okay.
Yeah, I just need
But
to be here. Are you having an issue?
Okay.
Yeah, no, I can hear. But thank you for checking.
Counsel, it might be advisable for you to slow down a little bit, because we are facing, bandwidth problems and everything. I think that will make your submissions much more easier to understand for us. Before you proceed, I would also like to pose a question to you. It is fair enough that you mentioned that the principle of complementarity applies here. Could you explain why the member nation is not willing or does not look able to make these prosecutions itself? What is the basis that you're claiming that the complementarity principle should kick in this particular case?
Much obliged, Your Excellency. Your Excellency, we are saying about the complementarity principle as because the defense might argue that there was not a conflict in the region of Zendik, which is why we are making ourselves clear that this state has passed the admissibility requirement of Article 17 as was required in the Article 53, paragraph 1, clause B. In that
Counsel,
regard,
that is understood.
Clear that there is.
Yes, so it is understood that the principle applies. The question really is why it applies in this particular case. What evidence points towards the reason that the International Criminal Court should be the proper trial court for this case and not the national courts?
Much obliged, Your Excellency. Your Excellency, as I was saying, Your Excellency, Zendik in the current case, the government of Zendik has shown unwillingness to conduct any investigation in relation to the PPP report and to the people's murders between 2011 and 2014. Throughout the fact sheet, there has been no single evidence that the government of Zendik, my apologies, had initiated any kind of investigation or had taken any steps, which is the reason why the prosecutor is submitting that this case should be admissible in the current court. Much obliged.
Right, thank you, Counsel. Just a very quick. Sorry, just a quick follow-up. Is delay in prosecution alone an adequate basis for complementarity to kick in? Do we need something more?
Your Excellency. Yes, Your Excellency. Your Excellency, as I have already mentioned, Your Excellency, the burden of the proof falls on the state to provide the court with evidence with certain degree of specificity and provide value that they are willing to take a certain step. As it was mentioned in the fact paragraph, Your Excellency, that the court system, the judicial system, is completely corrupted and it is being taken over by the ex-military officers, which shows that it is highly unlikely and highly improbable that justice will be served if the case is actually just adjudicated in the national court.
Land Counsel, but the Honorable Attorney General is there. He is a very prudent man, and he's a follower of the rule of law. So what is the impediment of initiating an investigation in the domestic in the domestic court? So you have to have initiate an investigation. The court's role will come later on. So there is an honest Attorney General in the country. So what is the impediment?
Much obliged, Your Excellency, for your concern. Your Excellency, in the same paragraph that you have referred, there is a follow-up line which says that there is also a group of criminal defense lawyers who are determined enough to stop any justification, to stop anyone from getting proper justice or from anyone to be punished in the court. Furthermore, Your Excellency, it is also mentioned that the court itself is actually not completely determined to the rule of law. Only the Attorney General himself cannot prove or cannot actually give justice to the 12,000 people that have been killed, Your Excellency. In that regard, the ICC being completely recognizable and being completely determined to the rule of law, the prosecutor believes that ICC is the proper forum to adjudicate the situation of Zendik, Your Excellency. Much obliged, Your Excellency. Much obliged, Your Excellency. Your Excellency, moving forward, the case is of sufficient gravity to justify the further actions of the court Your Excellency, in determining the gravity of a crime, such as its scale, nature, manner of commission, and impact of the crime, and also other circumstances has to be looked into, Your Excellency. When the gravity of the charges reach a certain threshold, it is utterly inappropriate to exclude relevant evidences, as already has been provided by the prosecution that there has been a killing of 12,000 people, Your Excellency. Your Excellency, in the fact paragraph number 26, it is also been stated that the gravity of charges against Brigadier Xavier reached a certain level of gravity as the accusations brought forward are of crimes against humanity and are brought forward for war crimes, which both are of highest gravity, and therefore the prosecution submits that the court allows the investigation into the situation of Genji, Your Excellency. Your Excellency do not have that.
Counsel? The bench is just wondering, what is the legal threshold for gravity? It is agreed, it is prima facie agreed that the situation is grave, but how grave should it be for the ICC to begin investigations on the matter? Is there any rule that the court may use to measure whether or not it is grave enough?
Your Excellency, I apologize, Your Excellency, we do not have the proper knowledge as to the threshold of the gravity that should be reached in this case. However, as I have already mentioned, the right to life is the most intrinsic and the fundamental right of a human being. We cannot deny that 12,000 people have been, innocent civilians have been killed in the situation of Genji, which is why we are submitting that it has actually reached a certain threshold of gravity, Your Excellency. On that basis, we do argue and we seek the court. We seek this honorable court to allow the prosecutor to continue with the investigation. Your Excellency do not have further queries regarding issue 1. May I please proceed to issue 2?
Excuse me, counsel, have you addressed the issue of interest of justice yet, or will that be coming?
My apologies, Your Excellency, that will be coming, but I have said that because much appreciated for your concern. If I may proceed, Your Excellency. Your Excellency, this investigation also serves the interest of justice, Your Excellency, taking into account the gravity of the crime and the interest of the victims that have been killed. There are nonetheless substantial reasons to believe that an investigation would serve the interest of justice, which is why the prosecutor has come to this honorable court, Your Excellency. Your Excellency, therefore, the prosecutor submits that the requisite criteria for authorization of an investigation in the situation of Genji have been met, as there is a reasonable basis to believe that a crime within the jurisdiction of this court has been committed, and the case is also admissible under Article 17 of the Rome Statute, Your Excellency. Your Excellency, if you do not have further queries, may I please move forward to the next issue?
Yes, ma'am.
Much obliged, Your Excellency. Your Excellency, moving forward, the second issue is whether Brigadier Xavier should be held criminally accountable for committing crimes against humanity against the civilians of Genji as per Article 7, paragraph 1A. Your Excellency, the same article categorizes murder as crimes against humanity, and if the crime is perpetrated as a widespread or systematic attack directed against civilian population, knowledge of the attack.
Counsel, if you could just slow down, please. It is getting a bit difficult to hear.
Much obliged, Your Excellency. I'll try to take down my submission so that you.
I think counsel is freezing on my end. Are others experiencing that? Yes. Okay.
Likewise.
Oh, counsel is still freezing.
Lord Counsel, we can't hear you.
Counsel, perhaps you should turn off your video and then turn it back on. We'll see if that resolves it. Oh, did he leave? Oh, no, just other. Oh, yeah, appears a little bit better. But you were muted.
Am I audible now, Your Excellency?
Yes.
I highly apologize for the inconvenience, Your Excellency. Your Excellency, as I was saying, Article 7, Paragraph 1A categorizes murder as crimes against humanity if it is perpetrated as part of a widespread or systematic attack directed against any civilian population with knowledge of the attack. The prosecutor submits that all these elements have been proved. As the prosecution would like to move forward, Your Excellency, Brigadier Xavier has caused the death of more than one person as a part of a widespread and systematic attack against the civilian population. Your Excellency.
9 minutes left.
Counsel, if you may pause for a minute, I would like to ask you a question about the procedures right now. Correct me if I'm wrong, but what it seems to me that you're arguing is whether or not the defendant is guilty or not guilty of crimes against humanity. Is that right?
Yes.
Right. Then the question is, I'm sure you're aware that this is the pre-trial chamber. Is the guilt of the defendant really on the question in the pre-trial chamber? Are we trying in this particular chamber to determine whether or not the defendant is guilty?
Yes, Your Excellency. I appreciate your concern, Your Excellency, but in the fact paragraph 26 in the footnote, it was mentioned to us that it should be considered that the further two issues of crimes against humanity and the war crime can be adjudicated in the pre-trial chamber. That is why we are adjudicating. That is why we are submitting on those issues here. Much obliged, Your Excellency. Your Excellency, as I was saying, in the context of crime against humanity, an attack is distinct from the concept of armed conflict and not limited to the use of armed forces, as was enshrined in Punarat et al. Case in paragraph number 86. Your Excellency, in the event of a crime against humanity, the civilian population must constitute the primary target of the attack, which in this case has been done by the military forces of Brigadier Xavier. Your Excellency, Article 50 of the Additional Protocol 1 of the 1949 Geneva Convention defines civilian as an individual who is not a member of the armed forces or otherwise a combatant. Furthermore,
Lord Counsel, how can you say that the attack was widespread? How can you substantiate that the attack was widespread?
Okay, but Your Excellency, the attack was widespread because, Your Excellency, it was spread out throughout the whole region of Zanzibar, Your Excellency, killing a total number of 12,000 people. It was not an attack which was directed towards a huge number of people. However, it was directed towards 12,000 people of Zanzibar and all the tribal people, Your Excellency. In that regard, we are basing our argument that it was indeed a widespread attack, Your Excellency.
How do you make sure that the command was given by the Brigadier Xavier?
Yes, Your Excellency. Your Excellency, regarding that question, my co-counsel will be further explaining the security responsibility.
That may, but my specific question to you, how do you determine it as a counsel? Don't you have that command over all the issues in this case?
Much obliged, Your Excellency. Due to the time constraint, I was telling that, but if Your Excellency do have a concern,
we are now in question and answer session, so your time is stopped now. So you should answer.
Much obliged, Your Excellency. Your Excellency, regarding how the actions of the military are in connection with the Brigadier Xavier, Your Excellency, reading paragraph from 20 to 26, it can be seen that all the divisions of the defenders and all the military forces were in direct command under Brigadier Xavier. Furthermore, there was evidence that all the military forces did actually commit crimes against humanity, and also crimes. They were also connected with the crimes of rape, murder, burning, looting the villages, along with the killing of people. That regard, Your Excellency, due to the connection between, due to the nexus between the military and the highest commander being Brigadier Xavier, the prosecution shows that there is a connection between the actions and the commandments of Brigadier Xavier. Yes.
So you want to say that there is no direct command for killing, or you are also saying that there was no indirect command of killing? Is it your submission?
Our submission is that, Your Excellency, that the actions of the military were directly in connection with Brigadier Xavier, and the prosecutor also pleads the court to enable the prosecutor to actually investigate completely in the situation of Zanzibar Excellency through the relevant information and through the relevant facts that has been given to us. On that basis, we are arguing that there is
Counsel,
a connection.
If I may ask a clarifying question at this moment, is it that the counsels, the prosecution team is claiming that the defendant is guilty, because of individual responsibility, individual criminal responsibility, or is the defendant guilty because of command responsibility? What is the line of argument? So is this a crime of commission that the defendant has committed something or committed an order or has been complicit, or is it a crime of omission while the defendant has not done something that he was legally required to do?
Your Excellency, actually it is the latter one, Your Excellency. We are not arguing of individual commission of the crime. However, we are arguing about the superior responsibility that was awarded to Mr. Brigadier Xavier in connection with his military, and we are arguing that he has the superior responsibility to be held criminally accountable for crimes against humanity as well as war crimes, Your Excellency. Much obliged, Your Excellency. May I please proceed?
Before you proceed, could you elucidate, agreed that the prosecution is bringing the charges on the basis of, as you're directly quoting the counsel, superior responsibility. How do you plan to argue to the court that the defendant was a superior and therefore did not commit some of the actions that he was required to commit under law? What is the line of argument there?
Definitely, the line of argument in that would be that he had a superior responsibility and a connection with the military. Furthermore, he had knowledge of the crime, and moreover, he did not take any action even after he knew that there were perpetrations of crime taking place in the situation of Genocide. On that basis, we are trying to prove that there is a superior responsibility of Brigadier Xavier, which he has failed to fulfill completely, and that is why he should be held criminally accountable under the current crimes against humanity and war crimes.
Okay, do proceed.
Can I ask a quick question though? So I'm still not clear on your whether you're proceeding on a failure to prevent and punish basis, or if you're pursuing command responsibility where that individual is still directly responsible through his role as a commander. I feel as if you are citing both in your argument now. So is it the case that you're bringing it on both bases, or is it that you're pursuing one or the other?
It's the latter one, Your Excellency. Your Excellency, it is actually the latter one. We are saying that he had the responsibility and he had the complete command and effective control over all the militaries, which he had failed actually to stop the militaries to taking any negative actions which has been seen in the situation of Genocide. On that point, we are arguing.
Okay, that latter point you made just now, though, was again a failure to prevent or punish.
Exactly.
Yes. So you start with both, but or you start saying it's a direct command, but by the end you're also arguing failure to prevent or punish. But proceed on, because I think we want to hear more about the elements and how you're establishing liability.
Much obliged, Your Excellency. Moving forward, Your Excellency, the present, as I was arguing that the presence of individual combatants within the population attack does not necessarily change the fact that the ultimate character of the population remains for legal purposes are civilian one, even though there have been tribal conflicts, Your Excellency. The 12,000 people fall under the definitions of the civilian people, Your Excellency, as was mentioned in the case of Dalit, paragraph 136, Your Excellency. Moving forward, Your Excellency, in regard the nature.
So how are you establishing that it was in fact an attack directed against a civilian population, as opposed to an attack where a substantial number of civilians were injured, but the attack itself was not directed at civilians?
Your Excellency, even though an attack is not directed directly against the civilian population, an attack which is expected to cause incidental loss of civilian life, injury to civilians, damage to civilian objects, and even though that there has been a great military advantage anticipated in an indiscriminate attack, that attack itself is also prohibited, Your Excellency. The generic military and all the forces under the Brigadier Xavier as well as the Darcy defenders had actually perpetrated such attacks, even though they knew that it would come at a cost of the loss of 12,000 civilian people. And that regard, we are submitting that it is actually an attack directed against the civilian population. Much obliged, Your Excellency. For your reference, it is also provided in fact targeting before, Your Excellency. Moving forward, Your Excellency, Brigadier Xavier has full knowledge regarding the widespread attack. Your Excellency, knowledge means awareness that a circumstances exist or a consequence will occur in the ordinary course of events. Your Excellency, it becomes applicable if that person needs to engage in a conduct or that person needs to cause that consequences or is aware that it will occur in the ordinary events, Your Excellency. An individual can be said to have committed a crime when he or she physically perpetrates the relevant crime or engenders a culpable omission in violation of the rules of criminal law, as was mentioned in the case of Prakat Khati, Your Excellency.
7 minutes remaining.
Moving forward, Your Excellency, Brigadier Xavier, being the commander of the English military, has full knowledge, as mentioned in Fact Paragraph 26. My apologies, Fact Paragraph 25, Your Excellency. He had full knowledge that attack has been going on. There were indiscriminate attacks against civilian population and he did not actually take any precautions to prevent those, Your Excellency. Your Excellency, not only did Brigadier Xavier fail to take any precautionary measures, but allegations suggest that the military of all three categories frequently operated with or are supported by the English military and as reported by the TTP through the recruitment, arming, and training of militias by the English military, as mentioned in Fact Paragraph 14 and 24, Your Excellency. Your Excellency, therefore, on the basis of the confessional statement, along with the TTP report and witness statement, the prosecution submits that the activities of the Darcy defender and all other militias undoubtedly amount to crimes against humanity, inhuman acts of extraordinary magnitude, and as their commander, Brigadier Xavier, is liable to be charged with the crime against humanity under Article 7, Paragraph 1 of Rome Statute. With that, Your Excellency, I would like to conclude my submission if Your Excellency do not have any further queries. Your Excellency, I would now like to call upon my co-counsel to present her or to present the rest of the submission. Much obliged.
Thank you, Counsel.
May it please the court?
Yes.
Much obliged, Your Excellencies. Your Excellency, my name is Sanjida Haider Suha, and I'll be dealing with issue 3 on behalf of the prosecution. Your Excellencies, the Council submits that Brigadier Xavier should be held criminally accountable for committing war crimes under Article 8(2)(b)(1) of the Rome Statute. Your Excellency, the prosecution submits that Article 8(2)(b)(1) of the Rome Statute defines war crime as attacks directed against the civilians, or rather against the civilians not participating directly in the conflict or hostilities thereof. According to Article 9(1), Paragraph 1 of the Rome Statute, to interpret with Article 8, the elements of the crime should be taken into account. Your Excellencies, we are relying
Counsel,
on the case.
if I may interrupt, before going into the particulars of the actus reus of the crime itself, would you care to elaborate what the situation is on the ground? Is it an armed conflict? Why is it an international conflict? Does Article 8 apply at all? This particular case?
Indeed, Your Excellency, the article does apply in all because we want to rely on the fact paragraph number 12, where it stated that foreigners from Civilian and Sylvanian were also recruited to take part in fights as per the Darcy defender. In that regard, Your Excellency, we submit that the conduct took place within the context of an international armed conflict, which is one of the very important elements of the war crime, Your Excellency.
Sorry, Counsel. I would ask you to repeat the argument again with emphasis on answering this question. Is it sufficient that foreign soldiers are involved in some sort of armed incidents to qualify a situation as international armed conflict? What is the legal criteria for the court to be convinced that it is indeed an international armed conflict, and the Geneva Conventions, the relevant parts, and in particular Article 8 applies here.
Indeed, Your Excellency. Your Excellencies, as I have mentioned, that for proving war crime, all the 5 elements of the Article 8 should be applied in this regard, from which one of the element is regarding the the intervention of the foreigners, or as stated as international armed conflict, Your Excellencies. I'm relying on one of the element which states that the conduct took place which is associated with an international armed conflict, and I'm putting my argument.
What are the elements of the international armed conflict?
Your Excellencies, the elements for armed conflict is there are actually 5 elements which constitute a war crime. One of is there must be an attack on civilians. And
sorry, Counsel, that is not the question. The question is what situation needs to prevail for the court to know that a situation is an international armed conflict in particular?
Indeed, Your Excellencies, for that the actions of the recruited civilian and civilian individuals can be attributed to the Darcy defenders. An armed conflict that is an internal at glance may become international or exhibit an international character when another state intervenes in that conflict through its troops. This was cited in the case of Prosecutor versus Jadrango Perlik, which was heard in front of the ICTY. And moreover, Excellencies, it is not necessary for overall effective control by a group of another state. The overall control test is utilized to ascertain the foreign intervention of any sort.
Excuse me, Counsel. Is it necessary that the conflict be an international armed conflict?
No, Your Excellency, it is always not necessary that there should be an international armed conflict. There can be also national armed conflict. For basis we can distinguish it as a war crime, Your Excellencies.
Why are you choosing here to argue it's an international conflict? Why are you not just saying it's an armed conflict? Why do we need to go into this?
Your Excellencies, we are going into this on basis of fact paragraph number 12, where it states that foreigners from civilian and civilian were recruited in this as a members of the Darcy defenders, Your Excellencies. And there was also, we are relying on fact paragraph number 8, where it is stated there was increased access to weapons through the channels of Servanian and Sylvanian. Based on these 2 fact paragraphs, we are relying on the fact that there has been an international armed conflict, Your Excellencies.
Okay, Counsel. So since you insist on categorizing the situation as an international armed conflict, the natural question next would be, could you prove to the court, or could you persuade the court that there was either effective or overall control of any third state in this matter at all, since you've already stated that that is required?
Your Excellencies, we are stating the fact that there was people who were recruited from the foreigners to be part in this as a Darcy defender. However, what we are trying to prove in this regard is Brigadier Zavir was the person who was at the control and command of the Darcy defenders, on basis of which we are arguing that he should be held accountable, Your Excellency.
Okay, do proceed. It does not really answer the question, but we might come back to it later.
Much obliged, Your Excellency. Your Excellency, the prosecution submits that there was attack on civilians, with civilians being the object of attack, which proves the element 1 and 2. To constitute a war crime, it is sufficient to prove that the author directed the attacks towards the civilian population or the individual civilians. Moreover, the attacks on civilians are absolutely prohibited under international humanitarian law and is unjustifiable by any military necessity. Your Excellencies, TTP also cited materials indicating the recruitment, arming, and training of Darcy defender by the Zanzic military. From the fact, it is also evident that all 3 categories of Darcy defender deprive the entirety of the villagers of their civilian character by participating in indiscriminate attacks whereby they raped, killed, looted, or burned villages and operate which were supported by the Zanzic military forces, Your Excellencies. Your Excellencies, the perpetrator intended the civilian population as such, or individual civilians not taking part in any hostilities, to object the attack, Your Excellencies. For an attack on the civilians to be a war crime, the attack has to be willfully, referring to mens rea, encompassing both direct and indirect intentions of committing the crime, and it is an essential element in holding Brigadier Zavir criminally responsible. Your Excellencies, the conduct, as mentioned earlier, was in context with an international armed conflict. Your Excellencies, the perpetrator was aware of the factual circumstances that established the existence of an armed conflict, which also fulfills the element 5, Your Excellencies. A reasonable wealth person in the circumstances of the actual perpetrator could have expected excessive civilian casualties. Brigadier Javier has clear aware of the factual circumstances of existence of an armed conflict since he confirmed in paragraph number 25, where he stated he acted independently of Zenzik armed forces and take advantage of general climate in chaos and impunity to attack, loot, burn, destroy, and rape. Your Excellencies, now.
Counsel?
Indeed, Your Excellencies.
Sorry, so given the line of argument you're making, I believe it is necessary for us to ask you to explain again the same question that the Honorable Presiding Judge asked to your previous counsel. Are you claiming a failure to prosecute or prevent, or are you claiming a direct individual criminal responsibility either through being complicit or through ordering? What is the mode of liability that you're claiming in particular for the defendant under this charge?
Much obliged, Your Excellency. Your Excellencies, we are arguing on the basis of the doctrine of superior responsibility under Article 28 of the Rome Statute. Your Excellencies, we are arguing that doctrine of superior responsibility makes a commander accountable under Article 28 of the Rome Statute, that any military commander shall be responsible for crimes within the jurisdiction of the court, which was so committed under his command's effective command, control or authority, and given the commander had knowledge of committing the crime. Here in this year, the prosecution submits...
Is that enough? Is it enough that the commander knew that crimes were happening? Are there additional requirements for command responsibility to kick in? What are the elements, let's say, for the court to believe that, okay, this person should be prosecuted under that mode of liability?
Much obliged, Your Excellency. Your Excellencies, we are relying on the fact that there are 3 essentials to make superior responsibility, which is the superior subordinate relationship and effective control, the knowledge, and no reasonable and necessary measures to be taken. We are relying on all 3 things to prove that the Brigadier Javier was
okay, understood. So I would like you to then go directly to the element number 3 and explain what factual basis exists for us, for the court to believe that the defendant did not take what was reasonably expected, or like take any actions that were reasonably expected by law.
Indeed, Your Excellencies. Your Excellency, the first thing, a commander, since being a Brigadier Javier was the commander, he has the duty to repress the commission. Your Excellencies, Brigadier Javier did not take any steps, which was mentioned in the whole fact that to stop the crime against humanity and the war crimes. Being the superior commander, he already had the knowledge, and all he did was stated...
On counsel, Brigadier Javier was not the commander-in-chief. He is just a commander. He has just a simple post, that is, he has a designation like brigadier. He is not the commander-in-chief. The fact does not suggest it. Rather, the fact suggests that he has sometimes faced the praise for explaining the situation. So how can you give pardon on him as a commander-in-chief? How can you bring allegations? You are giving allegations that he is the superior, or he is not the commander-in-chief.
Your Excellencies, in the whole paragraph, Brigadier Javier was the only person who came across and was defending the army, and he was always, if you refer to paragraph number 14, where it is stated that the victim stated that the Darcy defenders were acting on behalf of the military forces under the command of Brigadier Javier, which shows that Brigadier Javier was in command of the Darcy defender, Your Excellency.
Okay, right, Your Counsel. Does the Council consider that to be sufficient evidence for the court to rely completely on to make the determination that it was indeed only Brigadier Javier and not some other brigadier or other commanders within the hierarchy who should be held liable? Why this defendant in particular?
Indeed, Your Excellencies, if I refer to fact paragraph number 25, where he was stated that he was denying the Zenzik military forces involvement within the Darcy defenders, he shows in every time when he, in terms of defending the army, stating that The army did not have any connection with Darcy Defender clearly emphasized the fact that since he was the highest commanding officer, he was always defending the Darcy Defender
Sorry,
as well as...
Counsel. Is that a factual error? Yeah. Please do proceed,
I just want clarification. I would like counsel to establish his effective control. I'm not hearing effective control through what you're describing. You're saying it was within his command structure, perhaps his jurisdiction, but how are you establishing effective control? It sounds like from the comments he was making, he was saying he did not have effective control over these individuals.
Indeed, Your Excellencies, for that regard, I'd like to refer to paragraph number 19, where a Darcy Defender person was asked that how they are being recruited. That time, the person said that after they are done with their training, their list is being sent to the military, which stipulates the fact that yes, from the Darcy Defender persons were actually recruited in the military and they were a part of it. And moreover, Your Excellencies, I would like to refer to fact paragraph number 23, where it states that there has been links between all three categories of the Darcy Defender. However, Your Excellencies, in paragraph number 22, it is clearly stated that the border manpower's personnel work alongside with the regular armed forces. This proves that they were together a whole command structures that were working under Brigadier Xavier, Your Excellencies.
Thank you.
Sorry, Counsel, but I fail to agree with the conclusion. I agree with the facts that you presented, but do the facts lead to that conclusion? All the facts point towards the fact that the defenders were part of the military or were part of the hierarchy, but what proves that they were under the command of the defendant in particular, not just part of the military, but part of the direct command of the defendant?
Your Excellencies, the Brigadiers aware. The victims, they themselves stated that they were attacked by the army personnel who were under the command of the Brigadier Xavier as per fact paragraph number 14. This is basing on that the victims' attacks, on basing how the victims indicated, we are making the Brigadier Xavier the defendant who is liable for the war and the crime against humanity, Your Excellencies. Okay. We're making him liable for that reason.
Okay, sure. Do proceed.
Much obliged, Your Excellencies. Your Excellencies, as the prosecution was argued, the prosecution submits that Brigadier Xavier is criminally accountable for all the violations committed in Zenzig by the Darcy defenders. Your Excellencies, there was a superior subordinate relationship and effective control. Your Excellencies, there was indeed a knowledge. Your Excellency, the commander can be held liable for having actual knowledge of the crime, Your Excellencies. As stated in the case of
2 minutes remaining. 2 minutes remaining.
Your Excellencies, indicia relevant for gathering knowledge can be the scope of illegal acts, time during when they took place, the location of the commander at the time, and the availability of the reports makes that Brigadier Xavier was well aware of the facts of the Darcy defenders as mentioned previously. Your Excellencies, if I refer to fact paragraph number 25, where he stated that the military forces that they take advantage of the general climate, chaos, impunity to attack, loot, burn, destroy, and rape. This itself clarifies that he had knowledge that there were being attacks, there were being lootings, there were being burnings, destruction, rape, and killing, Your Excellencies. Your Excellencies, he did not take any measures or necessary reasonable measures. A commander, being a commander, he has the duty to repress the commission of crimes by his subordinates as stated in the case of Prosecutor versus Cordic. The duty includes stopping the commission of the ongoing crimes and punishing the perpetrators after the commission. Brigadier Xavier failed to fulfill these duties when he denied any connection of violations committed by Darcy defenders within the Zenzig military and thereby remained silent to the acts of crime. Your Excellency, based on the report, witnesses, and circumstantial evidences, the prosecutor again argues that Brigadier Xavier, having the command over the Zenzig military in the relationship to which the Darcy defender, the attack was directed against the civilian, and such attacks on the civilians were not unintentional, rather they were systematic, and therefore making Brigadier Xavier criminally accountable for war crimes under Article 8 to be one of the Rome Statute. Your Excellencies,
Counsel,
wherefore, in the light of...
Counsel, I'm wondering you're referencing it being systematic. I'm also wondering why you've chosen to proceed ahead on a challenge of an attack directed against civilians when there's clearly allegations of murder, looting. That should be sufficient as a crime, as a war crime. Why have you not pursued those allegations?
Your Excellencies, we are relying on all the allegations that actually took place, and regarding the matter of stating it as a systematic and widespread as a systematic attack, because as I refer to fact paragraph number 13, where it stated it caused the displacement of large part of civilian population, which I think clarifies that this was actually systematic attack. And however, another most important paragraph which I want to refer is fact paragraph number 11, where it stated that the two rebel groups were arising in Zanzik, which was the civilian soldiers and voice risers, which were against the government. And initially reflected.
The query is not really that whether or not this attack was systematic. The query was, does it matter that it was systematic for the court to find, guilt in war crimes? Is the attack being systematic an essential ingredient of the crime?
Your Excellency, for constituting war crime, systematic thing is not very necessary. I was summing up my whole thing in light of the war crimes against humanity and the war crimes and doctrine of immediate responsibility. In light of that, for the sake of concluding the fact, I just stated the fact. But as a particularly not for war crimes, I was not stated the fact, if I'm not mistaken, Your Excellencies.
Understood.
Much obliged, Your Excellency. Your Excellencies, wherefore in the light of the facts stated, issues raised, authorities and everything, the prosecution humbly submits before this honorable.
Time is up.
Your Excellencies, may I get 30 seconds to wrap up? Much obliged, Your Excellencies. We want the court to declare that the prosecutor submits pursuant to the Article 15.3 of the Rome Statute to allow proceedings and investigation for the situation of Zanzik for war crimes and crime against humanity. And also we ask the honorable court to held Brigadier Xavier liable for under the Rome Statute for committing crime against humanity and war crime, and as the court thinks best to give an order. Much obliged, Your Excellencies. I'd like to conclude.
Counsel.
Now I'm inviting the defense counsels to present their case. Defense.
May it please Your Excellencies.
Counsel, could you just give the bench a few seconds
to
get some administration done? Madam President, I'm ready when you are.
Ready to go forward. Judge, are you also ready?
Yeah.
Okay. Yes, let's go forward.
May it please Your Excellencies.
Yes.
Much obliged, Your Excellencies. Your Excellencies, this is the first counsel on behalf of defense, and I am Gianni Masinaha. If Your Excellencies do not have any queries regarding the facts of the case, the counsel would like to proceed with the submission.
Let's go forward, please.
Much obliged, Your Excellencies. Your Excellencies, the first issue that is going to be submitted by the first counsel is whether the prosecutor may now move from a preliminary examination of the situation in Zanzik to an investigation. Your Excellencies, the prosecutor may not move from a preliminary examination of the situation to an investigation. In Part 5, Article 53 of the Rome Statute, it deals with the rules regarding initiation of investigation. Subarticle 1 of Article 53 talks about what prosecutor shall consider while deciding to initiate the investigation. According to Subarticle 1A of Article 53, the information at hand does not involve Brigadier Xavier in any criminal activities. The Darcy defender identifies into different categories. Your Excellencies, one category of militias operate mainly under tribal management. They also act on their...
Counsel, at this stage, where we're still just looking at situation, why do we need to even be looking at Brigadier General?
Much obliged, Your Excellencies. Your Excellencies, because the case constitutes that the prosecutor is bringing a charge against Brigadier Xavier as an individual, it is necessary to prove that any of the activities and the conflicts that have taken place in the Republic of Zanzibar do not in any way involve Brigadier Xavier, and thus to absolve the charges against him, we are talking about Brigadier Xavier in the initial process.
In the preliminary examination to investigation move, you're talking about a case, a particular case, not the situation in general?
Much obliged, Your Excellencies. Your Excellency, what the council meant was that the preliminary investigation into the activities of that have taken place in the Republic of Zanzibar, the council is trying to establish that the activities did not have any relation with Brigadier Xavier to absolve him of any criminal charges or to stop the preliminary examination into the situation of Zanzibar.
Okay, proceed.
Much obliged, Your Excellencies. Your Excellencies, the militia groups also act on their own initiative to undertake small-scale actions to loot property for personal gain. Brigadier Xavier has no connection to the borders manpower. If borders manpower are involved in atrocities, it is without any ties to Brigadier Xavier. As such,
excuse me, Counsel, what are the requirements to move from a preliminary examination to an investigation?
Much obliged, Your Excellency. Your Excellency, Article 53 talks about the initiation of investigation. The requirements are that in the state, in cases where the state is unwilling or unable to carry out an investigation, the court may allow the prosecutor to move into an investigation. In other cases where there have been obstruction of justice before, the court may ask the prosecutor to move into an investigation into the situation.
Would the council then be willing to make arguments on those fronts? Should complementarity apply? Is the state itself willing and or able to conduct investigations? Would you like to present arguments and factual basis on that end?
Much obliged, Your Excellency. Your Excellency, the council will submit arguments as to why the state should not conduct an investigation in the further proceedings. If Your Excellencies do not have any further queries, the council would like to resume.
Sure, proceed.
Much obliged, Your Excellencies. Your Excellencies, according to subarticle 1B, it is said that the case is or would be admissible under Article 17. According to subarticle 1A of Article 17, the case is inadmissible because Zanzibar have no reason to start an investigation into Brigadier Xavier. It is not that the Republic is not unwilling or unable, but because Brigadier Xavier has no connection, even remotely, to any atrocity that may be considered as crimes against humanity. Brigadier Xavier have also released an official statement as stated in the agreed upon fact that they act independently of the Zanzibar military forces and take advantage of the general climate of chaos and impunity. Your Excellencies, it is of grave importance to take into account that the conflicts between Zoic fighters and Darsim gathering was mediated by the government, which resulted into ceasefire. Again, the government considered intervening when these two groups started their military activities. Thus, the state has every intention of looking into cases and intervening which are of threat and real. But Your Excellencies, the Republic of Zanzibar have no reason to start an investigation into Brigadier Xavier since he has no connection to any atrocity.
Counsel, we understand though that it's being an accepted fact that there have been a large number of murders perpetrated against civilians, even if not against Brigadier General Xavier. What steps has the government taken to prosecute?
Much obliged, Your Excellency. If the council may ask, Your Excellency is referring that to what steps have the government taken to prosecute Brigadier Xavier as an individual or anybody who?
Yeah, anyone. Not Brigadier, just demonstrating that they actually are willing and able to prosecute.
Much obliged, Your Excellencies. Your Excellencies, as the Council have already mentioned that the government did try to intervene into these intertribal conflicts. Your Excellencies, if the Council may draw your attention that the Republic of Zanzibar does have a very honest Attorney General who is willing to abide by the rule of law. Rule of law, and the Republic of Zanzibar has every intention of looking into cases which are of real threat and real. However, the Republic of Zanzibar has no intention of looking into Brigadier Xavier as an individual because he has no connection to any atrocity.
I think that part is understood, Counsel.
Pardon, Your Excellency, the Council is not privy to the information as to how the domestic courts could investigate into other people who may be considered in the agreed upon facts.
I'd advise the Council to proceed with other arguments at this point.
Much obliged, Your Excellencies. Your Excellencies, according to Subarticle 1C of Article 53, there are nonetheless substantial reasons to believe that an investigation would not serve the interests of justice. The Republic of Zanzibar have been facing constant tribal conflicts and geographical climate changes. The term Darcy defender was used by victims and members of the authorities to describe particular men they had named as leaders of attacks on villages. It was later confirmed that these men were in fact members of the civilian soldiers. Again, a senior member of the local authorities had described one man as a local Darcy defender leader. Then again, the DPP obtained official government letter in which Zanzibar provincial authorities referred to the same man as being a member of the civilian soldiers. Finally, the man himself showed evidence that he was a member of Voice Risers. Your Excellencies, thus there is no definite way to identify the militias or tie the militias to the military forces. Thus, it has nothing to establish connections to Brigadier Xavier. Your Excellencies, if I may draw your attention that witnesses of the crimes have said that the Darcy defenders act with Brigadier Xavier, but their identification is very vague over here because they differ from person to person and from victim to victim. Sometimes the victims are saying,
I think we're delving a bit too much into the facts right now at a stage where you would agree we're not supposed to be reaching the merits at this stage where we're determining a movement from preliminary examination to investigation, correct?
Much obliged, Your Excellencies. Your Excellencies, the Council believe that the facts over here play a predominant role into the decision of the Chamber to start an investigation because, Your Excellencies, the preliminary examination into the situation would only be of any rationale if there is if the gravity of the case is of such. And as such, the facts are being stated by the Council to Your Excellencies from the very beginning.
So you don't believe that the crime with the killing of 1,200 is sufficiently grave?
Your Excellencies, these, as the Council have already stated, that these are inter-tribal conflict, and as such, the Council believes that the territory of Zanzibar has a predominant and prerogative right to conduct investigation at first, rather than taking it to the ICC at the moment.
And we also ask, what is the standard that the court should be using when assessing the interests of justice?
Much obliged, Your Excellencies. However, the Council is not privy to that information at the moment. Pardon, Your Excellency.
Okay, thank you.
Much obliged, Your Excellency. If Your Excellencies do not have any further queries regarding the first issue, the Council would like to move on to the next issue. Much obliged, Your Excellencies. Your Excellencies, the second issue that is going to be submitted by the first Council is whether Brigadier Xavier may be held criminally accountable for committing crimes against humanity against the civilians of Zanzibar under Article 7(1)(a) of the Rome Statute. Article 7(1)(a) talks about murder as a crime against humanity. There are three elements to the crime of murder. The number one being that the perpetrator killed one or more persons. Your Excellencies, Brigadier Xavier have not killed nor contributed to killings of people. The reality is that it cannot be determined from the agreed upon facts whether any of the perpetrators were under his commandment. Your Excellencies, Article 86, Subarticle 2 of the Additional Protocol of the Geneva Convention, 1, says that Brigadier Xavier is responsible
9 minutes remaining.
For breaches and activities of his subordinates. In Prosecutor versus Truger, it is stated, command does not arise solely from superior's formal or de jure status, but can also be based on the existence of de facto powers of control. The Council will prove that Brigadier Xavier did not have any de jure status nor any de facto powers of control on the militia activities which have resulted in Haifa in the Republic of Zenzek.
Council, are we still talking about the first element, or have we now moved on to another element, another component? I think you stated that the first element is the killing of one or more people. It seems like here we have the killing of 1,200 people, or 12,000 rather. So have we not satisfied the death requirement, and perhaps need to be identifying or stating more clearly what the next element is that we're looking at?
Pardon, Your Excellency, the Council did not comprehend your question properly. If you could kindly repeat.
Sure. Actually, let me alter it a bit. You said when you started that there were 3 requirements for the establishment of murder as a crime against humanity. Can you please just state what those 3 elements are that you'll be walking us through?
Much obliged, Your Excellency. Your Excellency, the first element is that the perpetrator killed one or more persons. The second is that there has been a widespread or systematic attack on civilian population. The third being that the perpetrator knew or had knowledge of such widespread or systematic attack being conducted on civilian population. The Council is right now in the first element, how it cannot be established in the individual case of Brigadier Xavier. If Your Excellency do not have any further queries, the Council would like to proceed.
Sure.
Much obliged, Your Excellencies. Your Excellencies, as the Council have already stated in Prosecutor versus Truger, command does not arise solely from superior's formal or de jure status, but can also be based on de facto powers of control. The Council further wants to prove that Brigadier Xavier did not have any de jure status or de facto powers of control on the militias who have conducted such atrocities. Your Excellencies, the Darcy defenders identifies into different categories. We have already pleaded that they undertake initiatives on their own and under mainly tribal management. A category is also controlled by senior tribal leaders, and Brigadier Xavier has no connection to borders manpower, and he has already denied any connection to the Darcy defenders and the militia groups with the military forces. Thus, there exists no de facto...
Land Council, please go to paragraph number 25.
Much obliged, Your Excellency.
The second line, he also asserted that they act independently of the Zenzek military forces and take advantage. Don't you think that this is sufficient for Mr. Xavier to be a commander of this attack?
Much obliged, Your Excellency. Your Excellency, the Council does not agree with what Your Excellency have stated right now. Your Excellency, Brigadier Xavier is a commander of a military force. However, the military force is not in any way associated with the militias, which the Council is trying to establish that he, of course, does not have any formal commandment, but there also exists no de facto powers of control that he somehow influenced any of the militia categories.
The military, Zenzek military has been providing arms, uniforms, training to the Darcy defenders. Is it true?
Much obliged, Your Excellencies. In the agreed upon facts, it has been stated. However, we cannot connect the chain of commandment to Brigadier Xavier. There has never been any shred of evidence or express statements in the agreed upon facts that Brigadier Xavier is the one who was overseeing the supporting, the recruitment, the training, the supply of arms to these militia groups. We cannot establish from the agreed upon facts that he was the commander-in-chief. We only know that he is a commander of the military forces, and as such, we cannot establish the chain of commandment of overseeing this recruitment or supplying of arms.
Why Mr. Xavier is giving comment in the press? Why?
Much obliged, Your Excellencies. Your Excellencies, Brigadier Xavier is only commenting on the allegations brought to him, which are of horrendous acts of crimes against humanity. And as such, he wanted to clear out to the Republic of Zenzik and to the outer world that the military forces, his commandment and his military forces did not have anything to do with the atrocities, and Darcy defenders are using the havoc and the chaos in the Republic of Zenzik to carry out such atrocities on their own initiatives, and has nothing to do with his chain of command. Much obliged, Your Excellencies. If Your Excellencies do not have any further queries, the Council would like to proceed.
Yes.
Much obliged, Your Excellencies. Your Excellencies, the second element is that the conduct was committed as a part of a widespread or systematic attack directed against the civilian population. In Prosecutor versus Kaishima and Ruzindana, it has been stated that the attack must contain one of the alternative conditions of being widespread or systematic. The ILC draft code of crime defines systematic as meaning pursuant to a preconceived plan or policy. There is no event or no shred of fact that can direct towards a concocted plan or policy of the military forces under Brigadier Xavier to launch attacks on the civilian, thus proving that Brigadier Xavier had no conduct towards a systematic nor a widespread attack on civilian population. Thereby, there has been no default of any law by him. Your Excellencies.
The question now is it required for the systematic and or widespread requirement that that the defendant in particular be connected with whether or not the acts were systematic or widespread? Do we make the determination of whether or not an act is systematic or widespread regardless of who the defendants are, or do we also consider the roles of defendants in making those determinations?
Your Excellencies, in the current element, we have to prove that only the conduct, regardless of who the defendant was committed as a part of widespread or systematic attack. So it does not involve Brigadier Xavier. However, the Council contends to the court that there is no systematic attack because in the agreed upon facts, there is no shred of evidence or any statement that says that it was a preconceived or pre-concocted plan or policy. As such, being systematic is out of the question. As of widespread, Your Excellency, widespread, according to Ruto, Koski, and Sang pre-trial chamber, on the basis of the material provided to the chamber, there are substantial grounds, and the chamber viewed as a whole that if the evidence shows it was massive, frequent, carried out collectively with considerable seriousness and directed. Your Excellencies, I would like to draw your attention to the word directed against a large number of civilian victims. Only then it will consist of the characteristics of being a widespread attack on a civilian population. However, again, in the agreed upon facts, there is no evidence that it was supposed to be directed at a civilian population. There has been no such statement. I hope the Council has answered Your Excellency's question.
So here is the question. The number of victims has been very large and they have been predominantly civilian. So how is the court to just dismiss the fact that there is no possibility that these attacks could have been directed against the civilians? All the victims seem to be civilians, and these victims seem to be in very high in number, in the tens of thousands. So how can the Council very casually discount the fact that there could have been a directed attack against the civilian?
Much obliged, Your Excellencies. Your Excellencies, the Council contends to the court that we are trying to prove Article 7(1)(a), that is the crime against humanity of murder, which involves Brigadier Xavier and his forces as he is commander of a military force. The Council would like to contend to the court that the Council is trying to prove that the military forces under the commandment of Brigadier Xavier did not conduct such a widespread attack on a civilian population. However, if tribal conflicts and because of the chaos of the tribal conflicts, such widespread attack has been committed on a civilian population, the Council does not contend that these did not happen. However, the Council does very dominantly would like to argue to the court that Brigadier Xavier or his military forces had nothing to do with such conducting of widespread attack against the civilian population. Much obliged, Your Excellencies. If Your Excellencies do not have any further queries, the Council would like to proceed. Much obliged, Your Excellencies. Your Excellencies, thus there is no actus rea of Brigadier Xavier in a systematic or widespread attack on civilians. Thus, this element of murder has failed to be established. Your Excellencies, the third element, the perpetrator knew that the conduct was part of or intended the conduct to be part of a widespread or systematic attack against the civilian population cannot be conclusively proven. In Prosecutor versus Radovan Karadzic, it is stated that the mens rea of murder includes both direct and indirect intent. Your Excellencies, Brigadier Xavier did not have any act or omission because he did not provide any command to carry out any systematic attack against civilian population, nor was the military partaking in any such atrocities. Your Excellencies, the Pinpoint had reported that it is impossible to define Darcy defenders as the identity of the attackers differ from witness to witness and victims. Your Excellencies, Brigadier Xavier did not have any intention. We cannot conclude any such statement from the agreed upon facts. In Prosecutor versus Duskutedic, it was held that an accused...
Sorry, Counsel, let me just quickly interrupt you. How about the fact that the Brigadier keeps defending the actions of the military, keeps appearing in the press, trying to defend what is happening? Does that provide the court any evidence that the Brigadier is trying to suppress the issues or trying to, does that constitute any evidence of mens rea?
Much obliged, Your Excellencies. Your Excellencies, the Council would like to contend to the court that no, it cannot be considered a concrete or anything that shows that Brigadier Xavier had a propaganda of launching civilian attacks. Brigadier Xavier only appeared before the media because he was being accused of committing crimes against humanity, which are actually a very high allegations for military personnel, and as such, the council would like to pledge the court that they do not take these as evidences because these are very vague and at best circumstantial. These are not concrete and is not enough to prove mens rea, that is the intention of Brigadier Xavier. Much obliged, Your Excellencies. Your Excellencies, in Prosecutor versus Duskutedic, it was held that an accused may be found culpable if it is proved that he intentionally commits such a crime. Your Excellencies, Brigadier Xavier did not know about the conducts pertaining to a systematic attack on civilian population. It is only said that from the agreed upon facts that victims have witnessed that Brigadier Xavier, along with Zenzik military forces, along with Darcy defenders, were committing such crimes. But the Council have already contended to the court that we cannot identify the Darcy defenders. Sometimes they were civilian soldiers and sometimes they were voice risers. And as such, this statement cannot be relied upon. From the fact, it can be said that Brigadier Xavier had no intention to commit an attack. Therefore, the question of knowledge about the attack committed is immaterial here. If Your Excellencies do not have any further queries regarding the issues submitted by the first council, the council would now like to call upon the second council to make submissions to the Honorable Court. Much obliged, Your Excellencies.
May it please Your Excellencies. Much obliged, Your Excellencies. Your Excellencies, this is Saira Tori on behalf of the defense. And this is the second council on behalf of the defense. If Your Excellencies do not have further queries, the council would like to proceed with further arguments.
Yes, please.
Much obliged, Your Excellencies. Your Excellencies, the third issue that is going to be addressed by the second council is that whether Brigadier Xavier may be held criminally accountable for committing war crimes under Article 8(2)(bi) of the Rome Statute or not. Your Excellencies, no, he should not be held liable for committing war crimes under Article 8(2)(bi) of the Rome Statute. Your Excellencies, Article 8(2)(bi) talks about war crimes of attacking civilians. There are 5 elements to prove the crime. The first one is that the perpetrator directed an attack. Your Excellencies, according to the fact, Article number 25, Brigadier Xavier gave an official statement. He denied the Zenzik military forces' involvement with Darcy defenders. He also said that they take advantage. Much obliged, Your Excellencies.
Before we go into the actus reus, the mens rea, the particular elements of the crime itself, I think it would be informative for the bench if the council could first qualify the situation on the ground, whether or not, what is the nature of the situation in the ground? Is it an armed conflict at all? If it is an armed conflict, what is the nature of that armed conflict?
Much obliged, Your Excellencies. Your Excellencies, this is something internal conflict. This is not an international armed conflict at all.
Does that matter for a war crime?
Your Excellencies, Article 8.2f of Rome Statute of International Criminal Code specifies that the provision of war crimes committing in non-international armed conflict does not apply to the situation of internal disturbance and tensions such as riots, isolated, sporadic, or any kind of violence.
Or any kind of violence? Wouldn't an internal civil war be sufficient?
Beg pardon, Your Excellency?
Would an internal civil war be sufficient?
Your Excellencies, if the council, if you look at the fact, page 4, Article 10, there was internal tribal conflict between Zoic fighter and Grassy tribals for a long time. For these clashes, it also be the part of the conflict. So this could be the part of the conflict, and for that reason, this should be held as war crime, and thus Brigadier Xavier should not be held liable for this crime.
Okay, so a war crime can only be, your understanding under the Rome Statute is a war crime can only be for an international armed conflict, and that
much obliged, Your Excellencies. There are 5 elements to prove the war crime according to Article 8.2bi, which talks about the perpetrator directed an attack. The second one is the civilian was the object of the attack. The third one is the perpetrator intend the civilian as a object of the attack. The fourth one is there was an international armed conflict. And the fifth one is the perpetrator was aware of the factual circumstances of armed conflict.
Thank you.
Much obliged, Your Excellencies. If Your Excellencies do not have further queries, the Council would like to proceed with further arguments. Much obliged, Your Excellencies. Your Excellencies, the case Prosecutor versus Abu Ghraida, it was stated that there must be a causal link between the perpetrator's conduct and the consequences of the attack. As Brigadier Xavier was commander, as per, so the doctrine of command and the subordinate member followed his command. But he gave an official statement that, and he denied the involvement with Dashi defenders. He is not liable for this at all. Moreover, the fact states that there was a huge confusion about who are actually Dashi defenders. So it is crystal clear that Brigadier Xavier did not direct the attack. Your Excellencies, the second element is that the object of the attack was a civilian population. Your Excellencies, in the case Prosecution versus Katanga and Chui, it was decided that the war crime of attacking civilian population and civilians who are not taking direct part in hostilities in the first in the series of war crime. But Your Excellencies, Brigadier Xavier denied the involvement with Dashi defenders. Moreover, there are many clashes which are done by the members who are not the member of Dashi defenders, and there are also inter-tribal conflicts. Such a man who was confirmed by a member of Dashi defenders by civilians, later the man himself showed the evidence that he was a member of Voice Raisers according to Article 17 of the Fact. So it is clear that a group of people wanted to make the confuse the civilians and those directed
2 minutes remaining.
But the Brigadier Xavier was not aware of the situation, and thus he should not be held liable. The third one is that the perpetrator intended the civilian. Your Excellencies, the case Prosecutor versus Gallic, it was stated about the mental element of the attack. Your Excellencies, according to Article 30 of Rome Statute, it was stated that to prove a person criminally responsible and liable for a punishment for a crime, the material elements are committed with intent and knowledge. But Your
please read the prayer of your memorial, defense memorial. You prayed that Xavier is not liable for the offense crimes against humanity and war crimes. This is the prayer, but it didn't pray for that the investigation may not conduct. So, I mean, you want the preliminary examination to be continued, but Xavier is not liable. Is it?
Yes, Your Excellencies.
So you agree that there should be a preliminary examination into the situation of in Zenzik to an investigation, but is it your argument?
Much obliged, Your Excellencies. Yes, Your Excellencies. If the prosecution wants a preliminary examination, they can move on for that. But whatever the situation is, the Brigadier Xavier should not be held liable as the elements are not proved.
So you are advocating only for Brigadier Xavier.
Beg pardon, Your Excellencies?
So you are fighting for only acquittal of the Xavier, but you agreed that yes, there is a situation subsisting in the Zenzik and examination should be done by the international body.
Beg pardon, Your Excellencies. We don't want preliminary examination as he is not liable.
Okay.
Much obliged, Your Excellencies. Your Excellencies, the fourth point is that the conduct took place in the context of and was associated with an international armed conflict. Your Excellencies, the case Prosecutor versus Milan Metric, it was stated that an armed conflict exists whenever there is a resort to armed forces between states and armed violence between the governmental authorities and organized group or such group within a state. Your Excellencies, the fact states that the foreigners from Severin and Sylvian are recruited to take part in the fights as a member of Dashi defenders, but it does not imply that it was an international armed conflict. Your Excellencies, the fifth point is that the perpetrator was aware of the factual circumstances that established the existence of an armed conflict. Your Excellencies, the perpetrator was not aware of the factual circumstances that established the existence of an armed conflict. The case Prosecutor versus Gallic, it was stated that there must be a chain of command. According to the fact, Brigadier Xavier gave a statement by denying the Zenzik military forces involvement with Dashi defenders. The members of the Dashi defenders acted independently and as the perpetrator was not aware of the factual circumstances that established the existing of an armed conflict. If Your Excellencies do not have further queries, the Council would like to pray before the court. Much obliged, Your Excellencies. Your Excellencies, thus it is humble could the Council get 30 seconds more, Your Excellencies?
Sure, please proceed.
Much obliged, Your Excellencies. Your Excellencies, it is humble submission before the court that the accused should be declared as acquitted from the charges of crimes against humanity and war crime, considering the absence of the elements of crime, none of the offense that has been proved beyond of all reasonable doubt required in Article 66 of the Rome Statute. Much obliged, Your Excellencies.
Now we are moving to rebuttal session. I'm inviting the prosecution to present their rebuttal.
Before the prosecution begins, I just want to flag for my panelists that we are nearly at an hour and a half. So just for our own time and budgeting. Yes, and let's proceed.
Yeah, point noted. Also, is the defense supposed to go first or the prosecutor? Please do check that.
Much obliged, Your Excellency.
Apart from that, we're ready.
Sir, as per our direction, the prosecution are supposed to go first.
Sure.
Court officer, please.
Much obliged, Your Excellency. Yes.
We may proceed.
Counsels, are you ready?
We're ready. Is counsel ready?
Indeed, Your Excellencies. May it please the court, Your Excellency.
Yes.
Please proceed.
Much obliged, Your Excellencies. Your Excellencies, the Counsel of the Defense has mentioned the fact that the Attorney General is abide by the rule of law. However, they have failed to identify the fact that the principle of natural justice states that no one can be the judge of his own accord. Enlightening the fact, paragraph number 3, it is stated that the judicial branch is highly corrupt and biased towards military. Several of the acting judges are former members of the military, and up to today there has been no successful trial of the military official for their wrongdoing, which itself suggests as they were the former members of the military and in compliance with the principle of natural justice, which states that one cannot be the judge of his own accord, it is sufficient to prove that it was very hard and the government did not take any such sufficient steps. However, as mentioned by the Excellencies previously,
1 minute remaining.
That in the prayer, the defense has failed to state that the investigation should not be conducted. This clearly proves and it allows the prosecution and the court to allow the prosecution for giving the prosecutor should be given the permission to move on from a preliminary examination of situational sensing to an investigation. And the defense has also failed to give a concrete proof, and they have failed to identify the fact that there has been a killing of 12,000 civilians, Your Excellencies, because the word civilian itself is stated clearly, which indicates that they were not the persons conducting the hostilities were being killed. Your Excellencies, with this, the prosecution wants to conclude the submission if Your Excellencies does not have any further queries. May I conclude, Your Excellencies? Much obliged, Your Excellencies.
Now, I'm inviting the defense to present their rebuttal.
May it please Your Excellencies?
Yes.
Much obliged, Your Excellencies. Your Excellencies, my opposition counsel have failed to prove that there was any international conflict, which further have established that Article 8(2)(b)(1) have not been established, and as such, the criminal accusations against Brigadier Xavier cannot be proven beyond reasonable doubt as is needed under Article 66 of the Rome Statute. Your Excellencies, in the ICTY have said in Selvici case, they find effective control as the superior having the ability materially to prevent and punish the commission of the violations of international humanitarian law. Your Excellencies, the Council would like to contend that we have already argued and pleaded before the court as to how Brigadier Xavier did not have material control over the Darcy defenders or any other militias who have created havoc in the Republic of Zanzibar. Your Excellencies, as such,
1 minute remaining.
The court cannot contend that beyond reasonable doubt, it has been established that Brigadier Xavier had the actus rea and the mens rea to commit crimes against humanity. And as such, the court should not proceed with an investigation, nor should the court contend Brigadier Xavier to be criminally accountable for the crimes against humanity and war crimes. If Your Excellencies do not have any queries, the defense would like to rest. Much obliged, Your Excellencies.
The court will remain adjourned for 5 minutes, and next session will be started after 5 minutes. The teams will shift their representative party, and Team 2023 will be representing prosecution, and Team 2026 will be representing defense. Now, we are moving for break, and next session will be started after 5 minutes. Thank you.
I think, judges, I'm wondering if, are we not allowed to have a moment where we discuss? I'm wondering if we should go into a breakout room, or if that, is it not allowed for us to actually do that?
As far as our final evaluations in terms of the marks, I don't think we're supposed to collude, but I don't see why we cannot have administrative conversations, for example.
Yeah, this wouldn't be about the marking of counsel. It would be instead just more structural question.
Organizers, would it be okay for the judges to be put in a breakout room, or is this forum itself?
Okay, okay, Your Excellencies. We are creating a breakout room soon.
Sure. Could you give me a couple of minutes, though?
Okay.
Do create the breakout rooms, and I'll join in a minute if it's all right, Nicole.
Yeah, of course.
Sure.
Probably a separate room can be created in the and link should be given in the Facebook Messenger. Is it possible to create a breakout?
No, sir. We will create a breakout room and we will we will send a breakout room request and please accept that invitation.
Sure.
Dear court officers, please let the court know when 5 minutes is over. I hope.
Court officer?
Yes. Court officer, can you hear me?
Yes, I can hear you.
Okay. Let us know when 5 minutes is over. Thank you very much.
You're welcome.
Dear organizers, the time is over.
I'm ready when you are.
Dear court officer, you may proceed.
Thank you. Your Excellencies, may we start the court proceeding?
Yes.
Much obliged. Prosecution counsels, are you ready?
Yes, we're ready.
Thank you. Defense counsels, are you ready?
Yeah.
Thank you. Today, before the pre-trial chamber, the matter has been brought between the prosecutor versus Brigadier Xavier on the situation in the Republic of Zanzibar. With permission of the court, the proceeding is being started now. The court is in session. Now, I'm inviting the prosecution counsels to present their case. Prosecution.
May it please your Excellencies.
Do proceed.
Much obliged, Your Excellencies. Your Excellencies, this is the first counsel on behalf of the prosecution. If Your Excellencies do not have any queries regarding the facts of the case, the counsel would like to proceed with the arguments.
Yes, please.
Much obliged, Your Excellencies. Your Excellencies, the first issue that is going to be submitted to the Honorable Court by the first counsel is whether the prosecutor may now move from a preliminary examination of the situation in Zanzibar to an investigation. Your Excellencies, the prosecutor may move from a preliminary examination to an investigation. The Republic of Zanzibar has ratified the Rome Statute in 2002. According to subarticle 1A of Article 53, the prosecutor has reasonable basis to believe that a crime within the jurisdiction of the court has been committed. Your Excellencies, our NGO called The Pinpoint released an investigative report that reported the estimated killing of 12,000 civilians, destruction and burning of entire villages, etc. The report indicated that the term Darcy Defender has been widely used by victims of attack. The term has also been used by many international organizations and media. Victims have reported that the militia group Darcy Defender were acting with and on behalf of the Zanzibar military forces under the command of Brigadier Xavier. Many Darcians as well as non-Darcians are supporting the government and serving in its military forces led by Brigadier Xavier. Your Excellency, subarticle 1B of Article 53 says the case is or would be admissible under Article 17. According to subarticle 1A of Article 17, the case is admissible as the state is unwilling to carry investigation. Your Excellencies, the Council would like to draw your attention to page 2, paragraph 3 of the agreed upon facts, that the Zanzibar judicial branch is highly corrupted and biased towards the military. Several of the acting judges are former members of the military, and to the present, there hasn't been any successful trial of military official for wrongdoing. According to subarticle 1B of Article 17, the case is admissible as no investigation by the state has been carried out ever into the actions and events resulting from Brigadier Xavier's military decisions. Moreover, Brigadier Xavier have never been tried in any court of law under the subjects of the complaint. Therefore, Xavier can be tried in the ICC according to subarticle 1C of Article 17. Your Excellencies, this case is of sufficient gravity because the most significant element of the conflict in Zanzibar have to be the attack on civilians. Estimated 12,000 civilians have died in attacks, along with other crimes like looting, raping. These are all crimes against humanity. Thus, the gravity of the case is enormous, as well as the subject matter of the ICC. Thus, according to subarticle 1D of Article 17, it is admissible in court. Your Excellencies, defying what is stated in subarticle 1C of Article 53, there can be no substantial reason to believe that an investigation into the matter would not serve the interests of justice, given the fact that the courts of Zanzibar is biased and has a history of neglecting offenses of military officers. Your Excellencies, the appeals chamber in the situation in the Islamic Republic of Afghanistan stated, noting that the pretrial chamber's decision contained all the necessary factual findings and had confirmed that there is a reasonable basis to consider that crimes within the ICC jurisdiction have been committed in Afghanistan, the appeals chamber decided to authorize the opening of an investigation itself. Thus, the prosecutor should be allowed to move on from preliminary examination to an investigation. If Your Excellencies do not have any queries regarding the issue 1 submitted by the Council would like to move on to the next issue.
No questions on my side.
Much obliged, Your Excellencies. Your Excellencies, the second issue that is going to be submitted by the first Council is whether Brigadier Xavier may be held criminally accountable for committing crimes against humanity against the civilians of Zanzibar under Article 7.1a of the Rome Statute. Your Excellencies, Article 7.1a talks about murder as a crime against humanity. There are 3 elements to the crime of murder. Number 1 being that the perpetrator killed 1 or more persons. The Council is now going to explain how element 1 has been established. Your Excellencies, the victims of attack in Zanzibar have indicated that members of Darcy Defender were acting with on behalf of Zanzibar military forces under the command of Brigadier Xavier. According to Article 86, Subarticle 2 of Additional Protocol to the Geneva Conventions, as well as Article 28 of the Rome Statute, Brigadier Xavier is responsible for the breaches and activities of his subordinates. In Prosecutor versus Truger, it was said that it appears from the jurisprudence that the concept of command and subordination are relatively broad. Command does not arise solely from the superior's formal or de jure status, but can also be based on the existence of de facto powers of control, since Xavier was in command of Zanzibar military forces who were involved in attacks along with Darcy Defenders. Thus, Brigadier Xavier had effective control over the Darcy Defenders and his military forces, and is accountable for the atrocities committed by everyone involved in the process. Your Excellencies, in United States versus Yamashita, it was stated that while commander of the armed forces.
Counsel, to interrupt, sorry, I feel like we've now already moved on to the linkage evidence, which is the evidence connecting Brigadier General to the crime. But I'm not comfortable yet with the idea that you've established a crime against humanity has occurred. You've only told us that murders have occurred, but you haven't established that that was a crime against humanity. Can you please do that first?
Much obliged, Your Excellencies. Your Excellencies, the Council have mentioned that Article 7.1a of the Rome Statute talks about murder as a crime against humanity. It is stated in Rome Statute that element subarticle A of the Article 7.1 murder is a crime against humanity, and there are 3 elements of it: that the perpetrator killed 1 or more persons. The conduct was the conduct took place against a systematic. The conduct took place in a systematic or widespread attack against civilian population. And third, that the perpetrator knew or had knowledge that such widespread attack or systematic attack are being conducted against civilian population. By establishing the three elements, the council will establish that the crime against humanity of murder has been committed by Brigadier Xavier.
Well, those are the elements to establish the crime. And then in addition, you need to establish that the crime was committed by Brigadier General. So I'm asking you to first go through, so I'm clear on the crime itself, and then to show me how Brigadier General has been responsible. Or is responsible.
Oblige, Your Excellencies. Your Excellencies, the crime of murder consists of mens rea and actus rea. Your Excellencies, Brigadier Xavier have killed, the perpetrator being Brigadier Xavier have killed one or more persons because, as the council have already mentioned, due to a superior and subordinate relation that the council have already established. And the council would like to mention the United States versus Yamashita case, that while commander of armed forces of Japan at war, the commander unlawfully disregarded and failed to discharge his duty as commander to control the operations and committed high crimes against people of United States and of its allies, and he thereby violated the laws of war. This is relevant because Brigadier Xavier had effective control over the Darcy Defender militias as well as his military forces, and he has effectively failed to control the breaches of his subordinates to commit the crime of murder against people, and as such Brigadier Xavier has the actus rea. If Your Excellency permits, the council would like to establish mens rea in the further arguments rather than answering the question right now.
Counsel, very specifically, could you explain to the court why these attacks can be called either systematic or widespread? Like, why should the court believe that these attacks are indeed systematic or widespread?
Much obliged, Your Excellencies. Your Excellency, according to the Blaskik trial judgment, widespread means acts committed on a large scale and directed at a multiplicity of victims. Your Excellencies, here we can see that there have been estimated killings of 12,000 civilians, which is more than a multiplicity of victims. These attacks are frequent, massive, and conducted structurally, and as such, we can say that this is a widespread attack on civilian population. Those people.
How can we believe that it was conducted structurally? Frequent, even massive, I'd give you that, but the requirement that it is structured in any way?
Much obliged, Your Excellencies. Your Excellencies, the council would like to draw your attention to paragraph 15 of the agreed, pardon Your Excellency, the council would like to take your attention to paragraph 21 of the agreed upon facts, that the militias are organized in a paramilitary structure and in parallel to regular military forces, they conduct different crimes. In addition to that, the council would like to say that the military forces have provided with supplies of arms, ammunition, and have integrated Darcy Defender people into the military system, and then they have conducted raids and committed atrocities in civilian population. As such, with the evidence at hand from the agreed upon facts, it can be said that this is a widespread attack, Your Excellency.
Thank you. Do proceed.
Much obliged, Your Excellency. If Your Excellencies do not have any further queries, the council would now resume. Your Excellency, does Xavier killed people? Your Excellency, in Prosecutor versus Radovan Karadzic, it has been stated that the requirement that death must have occurred as a result of the perpetrator's act or omission does not require this to be the sole cause for the victim's death. It is sufficient that the perpetrator's conduct contributed substantially to the death of the person. Brigadier Xavier, this makes Brigadier Xavier accountable for killing of civilians further. Through his subordinates, he has failed to take effective control of his forces and the units, because it was his commandment of military forces that led the subordinates commit the crime of murder. Xavier substantially contributed to the death of civilians. Your Excellencies, going to the second element, that the conduct was committed as a part of widespread or systematic attack directed against a civilian population, the council would like to add that a category includes militias that are organized in paramilitary structure. They are headed by officers in the army. They operate within a defined command structure. Moreover, another category, borders manpower, that safeguards the borders of Zenzik, find alongside the regular armed forces. having an organized paramilitary structure, providing weapons, supporting the attacks of the militias, and helping them all across the Republic of Zanzibar shows definite
7
systematic
minutes
widespread
remaining.
attacks against civilian population and crimes against humanity was conducted against innocent civilians. In Prosecutor versus Radovan Karadzic, it is stated that as for the elements of the offense of unlawful attacks on civilians, they consist of act of violence directed against civilian population or individual civilians, not taking direct part in hostilities, causing death or serious injury to body or health. Your Excellencies, in Article 51, Sub-Article 2 of Additional Protocol 1 to the Geneva Conventions, it is stated that the civilian population as such, as well as individual civilians, shall not be object of attack. Your Excellencies, thus element 2 has been established. Your Excellencies, moving on to element 3, that the perpetrator knew that the conduct was a part of or intended the conduct to be part of a widespread or systematic attack against the civilian population, the Council would like to contend that in Prosecutor versus Radovan Karadzic, it is stated, as for the elements of the offense of unlawful attacks on civilians, they consist of, number 1, the offender willfully making the...
Why are we discussing the crime of unlawful attacks on civilians? Is that the charge that is being brought against the defendant here?
Much obliged, Your Excellencies. Your Excellencies, we are arguing this to establish element 3, which is necessary to establish the crime against humanity of murder that has been done by Brigadier Xavier in this instance.
Okay, do proceed.
Much obliged, Your Excellencies. Your Excellencies, they consist of the offender willfully making the civilian population or individual situation or individual civilians the object of those attacks, which means mens rea. Your Excellencies, the military force of Zanzibar under Brigadier Xavier have actively trained, supported, and helped militias during the attacks across Zanzibar over a period of 4 years, which clearly implies their assistance and intention of landing attacks on civilians. Your Excellencies, Brigadier Xavier was in control of military forces and units. These military forces are the ones who have accumulated Darcy Defender people, militias, and have conducted raids, looted and raped civilian population. As such, both direct and indirect mens rea have been established on the part of Brigadier Xavier. As for a lengthy period and timeline of 4 years, he has not intervened in any of the breaches committed by his subordinates. Your Excellencies, thus it has been proven that Brigadier Xavier is criminally accountable for murder as a crime against humanity beyond reasonable doubt as required by Article 66 of the Rome Statute. If Your Excellencies do not have any further queries regarding the issues submitted by the Council would now like to call upon the Second Council to make submissions to the Honorable Court. Much obliged, Your Excellencies.
May it please, Your Excellencies.
Yes.
Much obliged, Your Excellencies. Your Excellencies, this is the Second Council on behalf of the prosecution. If Your Excellencies do not have further queries, the Council would like to proceed with further arguments.
And I'm sorry, this is Sierra talking? For me, the video is blocked. It's frozen. Is that the case for others?
Before you proceed, Council, make sure that we
can... actually, she is joined with 2 IDs. Actually, Honorable Adjudicator, she is joined with 2 IDs maybe.
Beg pardon, I am not joined with 2 IDs.
Please quickly resolve the situation before you proceed.
Saira Tori?
Yes? Yes, Your Excellency.
Yes, your video is blocked. We actually watching is your...
Is this okay now?
No. Right now it's not, still it's not showing. Organizer, please notice when Saira can be available on camera and then just start the submission and time. Saira? Are you here?
Yes, I am here.
No, it's
yes,
okay.
now you, yes, it's okay.
Yes.
Is it okay?
Yes.
Yes, do proceed.
Much obliged, Your Excellency. Your Excellencies, if Your Excellencies do not have further queries, the Council would like to proceed with further arguments. Much obliged, Your Excellencies. Your Excellencies, the third issue that is going to be addressed by the second council is that whether Brigadier Xavier may be held criminally accountable for committing war crimes under Article 82bi of the Rome Statute. Your Excellencies, Article 82bi talks about war crimes of attacking civilians. There are 5 elements to prove the crime. The first one is that the perpetrator directed an attack. Your Excellencies, according to the fact, Dashi defenders...
Excuse me, Counsel. Can I ask, why did you choose to prosecute that as opposed to, I'm a bit confused because we're relying on Article 8.2b. Prior counsel was also talking about a crime of murder, so I understand that we're, looking at murder. So I'm wondering, why did you choose, B2 as opposed to willful killing?
Much obliged, Your Excellencies. Your Excellencies, according to the fact, it was mentioned in the fact that the prosecutor have to prove Article 82bi, which says about war crime, to help liable Brigadier Xavier. That's why the prosecutor tried to prove the Article 82bi of Rome Statute to help liable Brigadier Xavier.
Okay, thank you.
Much obliged, Your Excellencies. Your Excellencies, according to the fact, Dashi defenders are acting with and on behalf of Zenzik military forces under the command of Brigadier Xavier. When faced with rebellion in Zenzik launched by 2 rebel movements in 2011, the government called on a number of Dashi tribes to assist the fight. As Brigadier Xavier was a commander, as per the doctrine of command, the subordinate member followed his command. Your Excellencies, in the case Prosecutor
2
versus...
minutes remaining.
In the case Prosecutor versus Katanga and Chui, it was decided that the war crime attacking on civilian population and civilians not taking direct part in hostilities is the first series of war crime. Your Excellencies, the case Prosecutor versus Abu Garda, it was stated that there must be a causal link between the conduct of the perpetrator and the attack. Since there was a causal link, it is beyond a reasonable doubt that the attacks were direction of the perpetrator. Your Excellencies, the second point is that the object of the attack was a civilian population. Your Excellencies, according to the fact, the most significant element of the intertribal conflicts has been there, which has led to killing of an estimated 12,000 civilians. The TPP claims that the member of Dashi defenders has gathered substantial materials assisting the participation of the militia of the 3 categories of Dashi defenders. So it is clear that the object of the attack was a civilian population. Your Excellencies, the third point is that the perpetrator intended the civilian populations. According to the case Prosecutor versus Gallic, it was stated that there are mental element of the offense of an attack on civilians. The Article 85 of Protocol, Additional Protocol states willfully means the accused must have acted consciously with the intent. The activity is operated willfully by the command of the perpetrator. So it can be said that the perpetrator intended the civilian population as such or individuals who did not take direct part in the hostilities as object of the attack. Your Excellencies, the fourth point is that the conduct took place in the contest and was associated with armed conflict. Your Excellencies, according to the case Prosecutor versus Static, it was stated that armed conflict constituted a military organization. Here, the member of 2 neighboring states, Severin and Sylvian, took part in the conflict with Dashi defenders. The members are considered as representative of Severin and Sylvians. Salary was also paid for them by the government.
Time is up.
Could the council get 1 more minute, Your Excellencies?
Yes, I think your time was cut a little short as a result of the video, actually.
Much obliged.
Actually, the time was paused during her video cut. But
okay, there was just less time available.
Your Excellencies are okay.
Yeah.
Much obliged, Your Excellencies. Your Excellencies, a salary was also paid for them by the government of Zenzik. So the conduct was obviously an international armed conflict. Your Excellencies, the fifth point is that the perpetrator was aware of the factual circumstances. According to the fact, when faced with rebellion in Zenzik launched by 2 rebel movements early in 2011, the government called on a number of Dashi tribes to assist the fight. Dashi defenders were acting with and on behalf of Brigadier Xavier. There are also allegations that the militias of 3 categories are connected with each other.
To move to prayers. I don't think the time will allow you to make any more arguments.
Much obliged, Your Excellencies. Your Excellencies, therefore, Brigadier Xavier can be held liable for war crimes. If Your Excellencies do not have further queries, the Council would like to pray before the court.
Yes.
Sure.
Much obliged, Your Excellencies. Your Excellencies, therefore, it is the humble submission before the court that the accused should be declared liable for crime against humanity and war crimes. Much obliged, Your Excellencies.
Thank you.
Now, I'm inviting the defense counsels to present their case. Defense.
Am I audible?
Yes.
May I please the court? Much obliged, Your Excellency. My name is Ismail Ahmed Chisti, and I, along with my co-counsel, Sanjida.
Actually, counsel, I think your microphone might be a problem. Maybe, is it possible for you to try without your headphones and using just the microphone off your computer or phone? Because I think now, for me now, it's very bubbly, even more so than before.
Okay, I will try to change my headphone.
Counsel, if you don't move while you are arguing, there is, I think, sound may be good.
Now? Oh, you're muted?
Can you hear us?
Counsel is muted right now.
Counsel, can you please unmute yourself?
I think maybe without. Try without.
Am I audible now?
Yeah.
I think it's better. Can you speak again? Counsel, can you hear it? Can you do it? Can you do it without the headphones and just from the speaker from your computer?
Hello?
Can you keep talking so we can just practice?
Hello? Is it okay now? A bit okay. I'm having a problem with my earphones. So is it actually audible?
It's actually, it's a little less. This is back to what it was for me the first round. So we can proceed with this. It's not as bad as it was at the very start.
My apologies, Your Excellency. Thank you for consideration. Am I still audible?
Yes.
Yes.
Please speak slowly.
Okay, much obliged.
And don't move. Try to be. If you feel free, then you can sit and argue. So.
Much obliged. May I please record?
Yes.
Much obliged, Your Excellency. Your Excellency, my name is Ismail Ahmed Chisti, and I, along with my co-counsel, Sanjida Suha, are representing the defense in the case between Prosecutor versus Brigadier Xavier. We are representing Team 2026, Your Excellency. Your Excellency, I would like to begin my argument with the first issue, which is whether the prosecutor should be allowed to move from a preliminary examination of the situation in Zone 6 to an investigation. Your Excellency, it is the submission of the defense that the prosecutor should not be allowed to move from a preliminary examination to an investigation. Your Excellency, in order to determine that, the chamber must consider whether the requirements set out in Article 53, Article 53, paragraph 1, clause A to clause C of the statute are satisfied or not. Your Excellency, to begin with the first element, If the current situation fails the reasonable basis to believe that there has been any crime committed in the situation of Genji, Your Excellency. Your Excellency, the reasonable basis to believe text is considered to have the lowest evidentiary standard, and as it is based on logical interpretation. However, that logical interpretation standard should be construed and applied against the underlying purpose of the procedure in Article, as mentioned in Article 15, paragraph 4 of the Rome Statute. Your Excellency. This principle is to prevent the court from proceeding with unwanted, frivolous, or politically motivated investigation that could have negative impact or negative effects, rather I should say, on the credibility of the ICC, Your Excellency.
If I intersect here, correct me if I'm wrong, but it seems to me that the council is implying that if an investigation is conducted in this particular matter, it will naturally become politically motivated. So in terms of reasonable grounds to believe, the court has already been made aware of the fact that there has been a large number of deaths over a long period of time. Why would that not be sufficient for the court to believe that that there's reason to allow an investigation?
Excellency, the defense submits that since the investigation would cause an unwanted, and the result of the investigation would be unwanted and frivolous, and would be a wasting of time of the ICC if the ICC does actually move forward to an investigation, because it is the submission of the defense that the incidents in the situation of Genji were rather isolated and were not isolated and sporadic events of situations and atrocities committed in between 2011 and 2014. In that regard, Your Excellency, the defense is submitting that there is no reasonable basis to believe that there was actually that crimes that had been brought forward against Brigadier Xavier had been committed actually. Your Excellency?
Yes and no question. Just you can just answer yes and no without justifying the answer. So the court should take all of these events as cumulative, or should the court take all of these events as individual? What should the court do in this particular matter?
Your Excellency, the action should be taken as a sporadic and isolated event, not as a cumulative event. That is our submission in this case. Much obliged, Your Excellency. Moving forward, Your Excellency, furthermore, there has been no credible information or evidence found regarding linking the incident towards the of the Gentic towards the activities of Brigadier Xavier. Your Excellency, it is clear that there is no reasonable basis to believe that Brigadier Xavier was responsible in the activities of different groups of Gentic. Your Excellency. Moving forward, Your Excellency, in light of the claims made by the prosecution, the case is not admissible before the ICC as per Article 53, paragraph 1, clause B. Your Excellency, to prove this article, there are two elements that need to be present. First of all, the principle of complementarity. Your Excellency, the ICC is based on the principle of complementarity, whereby the court is subsidiary or complementary to the national court, which enjoy priority in the exercise of jurisdiction. Your Excellency. Your Excellency, the national courts have more means available to collect the necessary evidence and to lay their hands on evidences towards the accused, and also it respects the state sovereignty of the state. Your Excellency. Your Excellency, due to this principle, the court is barred from exercising its jurisdiction over a time whenever a national court asserts its jurisdiction over the same time, or under its national laws, the state has jurisdiction and the state is willing and has the ability of adjudicating the case in accordance to Article 17, paragraph 1, clause A of the Rome Statute. Your Excellency. Your Excellency, furthermore, Genji has the territorial jurisdiction of the case. Your Excellency, the basic principle of territoriality determines that a crime committed in a state's territory is justifiable in that state, a fundamental principle recognized in all systems of law as was enshrined in the SS Local State, paragraph 20. Your Excellency. Moving forward, Your Excellency, the local delicity committee, the place where the offense has allegedly been committed was within Genji, and it is where it is easiest to collect evidences. On this basis, Your Excellency, in the case of Generally, the defense would like to submit that the current Attorney General, who is the official head of all the prosecution officers in Brazil, is not a former military officer and he is committed to the rule of law. Furthermore, there is also an active committee of lawyers who are engaged in criminal defense. Therefore, it would be easier.
Excuse me, how do you explain the fact, though, that there have been so many deaths and no investigation or prosecution so far as we know have been brought? None have been brought. Yeah.
Much obliged, Your Excellency. Your Excellency, on that point, I'd like to state that the principle of nuclear test case, where it was stated that it is a well-established principle that case cannot be presumed under international law, and it is not mandatory to prove exactly when and how the investigation would be conducted, even though it has not been conducted yet. However, it will be conducted in due proceedings, as the fact has already mentioned that there has been a lot of tribal conflict and a lot of tension in the country. And once these have all been solved, the investigation will duly be proceeded. And the burden of proof whether the state would not actually conduct the investigation is on to the prosecutor, Your Excellency. On that basis, the defense argues that the ICTY, this pre-trial chamber, should not allow investigation into the situation of Zenzik. However, the government of Zenzik actually has the first priority to initiate an investigation into the situation. Mr. Excellency, do not have further queries regarding the first issue. I would like to move on to the second issue.
Please do.
Much obliged, Your Excellency. Your Excellency, moving forward to the second issue, whether Brigadier Xavier is guilty of crimes against humanity under Article 7, Paragraph 1A of the Rome Statute, the defense would like to argue that no, he is not actually criminally liable for crimes against humanity. Your Excellency, the charges of crimes against humanity cannot, my apologies, Your Excellency, to begin with, the charges cannot amount to mere suspicion or theory, but the evidence must be tangible.
9 minutes remaining.
Factual and concrete, as was mentioned in the case of Libangai in paragraph 39, Your Excellency. In case of an NAMDPC, the definition of the crime shall be interpreted in favor of the person being prosecuted as per Article 22, paragraph 2 of the Rome Statute, and the defense should and the accused should enjoy the burden of. My apologies, Your Excellency, on that point. I'd like to move forward, Your Excellency. Your Excellency, the first element of Article 7, Paragraph 1A is that whether the attack has been systematic or widespread. Your Excellency, widespread refers to the attack being conducted on a large scale as well as to a high number of victims it has to cause. Furthermore, the systematic emphasizes to the organized character of the attacks of violence and improbability of the random occurrences, as was mentioned in Punalat et al. Case in paragraph number 429. Your Excellency, to be systematic, the attacks have to be following a regular pattern on the basis of common policies involving substantial public or private resources, and there must be some kind of key-consist plan or a policy, as was mentioned in the case of Akayasu in paragraph number 5.8. Your Excellency, the defense contends that there has been several instances of violence against civilians over almost 2 years of Zenzik history. But the defense contends that they were all isolated small incidents with different intentions and different damages and collateral damages, not only caused by the military, but not only caused by the civilian soldiers, but the voice raisers, diocese defenders, etc., none of which were affiliated or initiated on a regular basis, and there had been no connection from the fact to prove that there had been actually any connection to these atrocities to the intentions of the
7 minutes remaining.
Counsel, just a quick question. Just as the counsel has mentioned that there are many organizations involved in the conduction of these violent activities, why therefore should the court not take the view that even if these events were not systematic, they were actually widespread, given that there were many organizations operating in the theater?
Yes. Much appreciated, Your Excellency. Even though the court may consider that these were widespread attacks, however, these were not conducted in a regular pattern, or these were not conducted towards all of the people. They were not intended to be attacks against all of the people. Rather, they were the result of the tribal conflict between all these tribes and organizations, Your Excellency. On that basis, the defense is arguing that the attacks were neither widespread nor systematic, but rather they were isolated attacks, which is why the Brigadier Xavier, having no connection with this attack, should not be held actually to being responsible for crime against humanity, Your Excellency. Moving forward, Your Excellency, the attack was not directed against the civilian population, Your Excellency. Directed against civilian population indicates that the civilian population should be the primary object of the attack, rather than incidental target of the attack, as was mentioned in the case of Zovita in paragraph number 964, Your Excellency. Your Excellency, the foremost lack of intention to direct attack against our civilian population can be inferred by the activities of the army, which avoided any affiliation with any of the rebel group or militia group, as they act independently of the government military forces, as was mentioned in Fact 6, paragraph 25, Your Excellency. Your Excellency, even though there can be stated that there were attacks, however, they did not interfere with the tribal conflict, and rather they refrained from sending any army to attack the rebels, rather considering the option of returning to peace as they had initially done, Your Excellency. Moving forward, Your Excellency, the principle of discrimination is also not true, Your Excellency. Indiscriminate attacks are those which are not directed at a specific military object, or which employ a method or means of conduct which cannot be directed at a specific military object, which in this case has been missing. Your Excellency, by drawing your attention to fact paragraph 16 and 17, the defense would like to contend that in Zenzik, the government or the forces under the commander of Linkage Evidence only took action when two rebel movements were launched early in 2011, and the government was forced to call on a number of Darcy tribes to assist in the fight, not the Darcy defenders. It is to be made clear that the intentions of the Zenzik military or the forces under Brigadier Xavier were not to harm the civilian population, but rather to contend or rather to protect the people from the rebellion movements that were rising from the civilian risers and the voice raisers, Excellency. On that basis, Your Excellency, the defense would like to conclude its argument that the Brigadier Xavier is not actually criminally accountable for the crimes against humanity of murder, Your Excellency. On that note, I'd like to conclude my submission if Your Excellency do not have any further queries, and I would like to call upon my second counsel to present the rest of the case.
Do call the second counsel.
May it please the court?
Yes.
Much obliged, Your Excellencies. Your Excellencies, my name is Sanjita Haider Suha, counseling appearing on behalf of the defense. Your Excellency, the counsel submits that Brigadier Xavier is not criminally accountable for committing war crimes under Article 8(2)(b)(1) of the Rome Statute. Your Excellencies, Article 9, read along with Article 21 of the Rome Statute, provided that in order to constitute a crime under Rome Statute of ICC, the elements of the crime must be proved. The war crime provided under this article of the statute is committed only when the act of violence is launched and is void of any justification, having caused deaths and or serious bodily injuries within the civilian population during an international armed conflict. The defense contends that Brigadier Xavier is not liable for such war crime as the elements are not fulfilled. Your Excellencies, moving further, there was no attack which was directed against the civilian population. In the case of Prosecutor versus German Katanga, the war crime provided under this article is committed only when the attack is launched deliberately against civilians in course of an armed conflict and which is not justified by military necessity. Your Excellencies, Brigadier Xavier is not the commander of the Darcy Defender, and their activities have no relationship with the government military. Despite the allegations of the rebel working forces under the government military, the government has already denied such claim. The only evidence includes the isolated and disorganized attacks of the civilian soldiers, voice risers, and Darcy defenders, which has no connection with Brigadier Xavier. If I may refer to fact paragraph number 17, Your Excellencies. Even if the court finds that there was intent and attack, the defense contends that Zenzik army, who was under the command of the accused, only engaged in mediating the tribal conflict in Zenzik. Your Excellencies, there were members of Borders Manpower, which is a group established by the Zenzik law to safeguard the borders of Zenzik as per fact paragraph number 22. Your Excellencies, moving further, the conduct did not take place in context and is not associated with an international armed conflict. Your Excellencies, referring to the case of Prosecutor versus Furundija, war crimes can only exist in state of armed conflict. In Prosecutor versus Linkage, the situation of internal
2
disturbance,
minutes remaining,
such as riots, isolated sporadic attacks of violence, this does not constitute an armed conflict, Your Excellencies. Your Excellencies, the perpetrator was not aware of the factual circumstances that established the existence of an armed conflict. According to our...
Before you move on, counsel, could you clarify to the court why this is not an armed conflict? What is needed for there to be an armed conflict? What are the elements? And could you justify why those elements are not fulfilled particularly?
Indeed, Your Excellencies, for being an armed, I would like to refer to paragraph number 13, where it is stated that regardless of the fighting between the rebels, government, and Darcy defenders, the significant element of internal tribal conflict has been the attacks on civilians. There was no, in the fact, it was stated that due to the armed conflict, there has been a death of 12,000 civilians. The defense is not denying to the fact of killing of 12,000 civilians, rather it was a result of the internal armed conflict, Your Excellency. Internal tribal conflict, my apologies, Your Excellencies. It was indeed...
Internal tribal conflict not constitute an armed conflict by itself?
Your Excellencies, I would like to refer to the case of Prosecutor versus Linkage, where it states that internal disturbance like riots, isolated and sporadic attacks does not constitute to an armed conflict, Your Excellencies.
But the number of victims here, number 20,000, how can the court be persuaded that these are just sporadic activities or just internal disturbances?
Your Excellencies, because in this regard, this was due to the internal tribal conflict, and given that the history of Zenzik, where there has been a drought and desertification, the prosecution failed to identify that fact, and there has been a lot of casualties going on in this country between the civilians themselves, due to the fact that there was lack of fertile lands and soil, as per paragraph number 6. So it states that there was an internal problem, which was internal dispute that was going on in the Zenzik, rather than the armies were being appointed to attack and kill.
Proceed with your argument.
Yes, Your Excellency. May I proceed, Your Excellency?
Yes, please.
Much obliged, Your Excellency. Your Excellencies, there has been no liability under the doctrine of superior responsibility, Your Excellencies. Criminal responsibility within the meaning of Article 21A establishes when there is a superior subordinate relationship. There has been an absence of superior subordinate relationship and effective control. There has been a lack of knowledge, and there has been no possibility of reasonable and necessary measures to be taken, Your Excellencies. Based on that, we rely our argument that there has been no criminal responsibility of Brigadier Zavir under Article 28 of the Rome Statute. Your Excellencies, the defense contends that since there is a lack of superior relationship as well as the element of knowledge, no question arises in taking the measures to prevent, which also proves that there has been a lack of power, and which has proved that there has to measures to be taken to measures to prevent to take such actions, Your Excellency. Hence, there is no liability for Brigadier Zavir under Article 28 1B of the Rome Statute.
I'm sorry, I think I didn't quite catch that statement again. Can you say that? Just repeat that line again, please.
Indeed, Your Excellencies, there has been a there has been a lack of superior subordinate relationship, as well as the element of knowledge is missing. So since these two things are already missing, so how can Brigadier Zavir take a responsible and necessary steps in this regard, Your Excellency? There might be casualties which should be solved by the government, and the government which the government is trying, and Brigadier Zavir, being the commander of the army, has no relationship, since his superior commander did not do anything, as also stated in the fact that there is no organized structure of the Darcy defenders, Your Excellencies. With that note, Your Excellencies, the defense want to conclude with one of the point that in the submission of the prosecution, they have failed to mention that there needs investigation. Rather, they were focusing only on giving the court verdict and prosecuting Brigadier Zavir for crime against humanity and war crimes. They themselves are not willing to want the court to order that there should be an investigation. Hence, I would like to conclude and rest my case if Your Excellencies does not have any question.
Time is up.
Much obliged, Your Excellency.
Now we are moving to rebuttal station. I'm inviting the prosecution to present their rebuttal.
Before the learned counsels go to rebuttals and sub-rebuttals, just a reminder to keep your arguments just about the rebuttals and not try to present new arguments and facts at this point, because the bench will not be able to make heads or tails of those new facts and arguments. But we can proceed.
Please, Your Excellencies. Much obliged, Your Excellencies. Your Excellencies, the requirements set out in Article 53, Subarticle 1, A to C of the statute are satisfied. Thus, an investigation should be allowed by the Council. Your Excellencies, this proceeding is not frivolous or politically motivated. Your Excellencies, estimated 12,000 civilians have been reported to be dead. There are paramilitary structures and widespread attacks are being committed against civilian population. This proceeding serves as the interest of justice as international laws have been broken. Your Excellencies, crimes have been committed for a very lengthy period of time. No intervention or any step have been taken to stop atrocities. Brigadier Xavier, being the commander, took no step, even though training was provided, ammunition provided, and people integrated into the military forces. These, along with 12,000 civilian casualties, is more than basis enough for the court to intervene. Your Excellencies, according to the agreed upon facts, the national courts are biased towards military officials. No investigation has been conducted, which gives
1 minute remaining.
Ground to investigate, as the state is unwilling, as previously pleaded by the Council. Your Excellencies, the charges do not amount to mere theory or suspicion, and is neither ambiguous. The facts are concrete, tangible, and factual. Brigadier Xavier, for a very long time, have not intervened in the breaches committed by his military forces. Under commander's responsibility, he is responsible. Your Excellencies, the trial chamber in Orange held that the intent to kill is required in order to fulfill the mens rea of murder. This includes proof of a mental state wherein the perpetrator foresees, as more likely than not, the death of the victim could occur as a consequence of his act or omission. Your Excellencies, Brigadier Xavier has committed omission time and time again for a timeline of 4 years. He has actively failed to take control of his military forces and could not intervene in the breaches. Your Excellencies, in the Milutinovic case, the trial chamber held
Time is up. Time is up.
If Your Excellencies do not have any queries, prosecution would like to rest.
Thank you. No further questions.
Much obliged, Your Excellencies.
Now I'm inviting the defense to present their rebuttal.
May it please the court?
Yes.
Much obliged, Your Excellencies. Your Excellencies, the prosecution has failed to prove that there is a reasonable basis to believe and proceed. They only talked about the various confusion of the term Darcy defender, but they failed to show that the investigation and using the previous time of ICC would be a fruitful result. Your Excellency, Zenzik has not yet denied any investigation, but rather it is praying to this court to allow it to be the first investigator on the ground of complementarity and territoriality. Your Excellency, there's a lack of argument for a permanent connection with Brigadier Zarif, and so themselves have acknowledged that there are allegations which are based on presumptions and assumptions, and there is no concrete proof of superior subordinate relationship, which is primarily the requirement to hold Brigadier Zavir liable. Your Excellency, they failed to prove the knowledge element of Brigadier Zavir and how the attack was directed against civilian population.
1 minute left.
As per facts, there are no indications of such, but rather only the good intention of the military to resolve the duress in Zenzik. Your Excellencies, they have denied the international armed conflict, but rather have agreed upon the armed conflict, which attracts a different set of international law. They themselves are not sure of the nature of the conflict, which is the reality is a tribal conflict, which is clearly mentioned in fact paragraph number 11. Your Excellencies, lastly, they have not prayed for the investigation to this court, and based on their other arguments, their arguments indicate clearly that there is no reason to investigate into the situation of Zenzik and Brigadier Zavir as not guilty of committing crimes due to the lack of connection as cited atrocities, and therefore the defense pleads the court to dismiss this weak and politically motivated argument that is wasting the time of the court and is also harming the credibility of the honorable court. Your Excellencies, if you do not have any question, the defense would like to respond.
Time is up.
Much obliged, Your Excellency.
Thank you, Counsel.
Counsel.
The court is adjourned now. Participants are requested to join the closing ceremony and leave the courtroom. Result?
No.
Don't go. Stay.
Your counsel, we are instructed to announce that.
Yeah, I think this was part of, I think your colleague was in the breakout session, but you were not. Our hope was when we concluded, we wanted to just take a moment because I don't think we're going to have an opportunity otherwise to speak with the counsel. So
Your Excellencies, sure, Your Excellencies, you may have the floor, please.
Yeah, great. So we're not going to talk about any scoring or any particulars. Hello? Oh, so I was hoping instead that we could just take a moment because there were a couple of areas of points of law and also just about procedure that came up while we were in the process of these proceedings that, if we can have you present, it would be helpful to clarify them because otherwise I don't think we're going to have a chance. So first, I do want to say congratulations to everyone who participated. You made it to this round, which is a huge testament to your work. And you all did an extremely good job. I think we can speak in general terms insofar as this is a very stressful situation to be in. You are facing questions from people you don't know and are having arguments arguably picked apart in ways that hadn't been before. So I commend all of you on your work and am grateful to have been able to participate in this. And I'm not sure if my colleagues want to say anything about that before we move on to a couple of substantive points.
I think we should do that in the interest of time.
Yeah, so if it's all right with my colleagues, I'll jump ahead and then if they'd like to intervene at any point or if they disagree, that please do jump in. So a couple of things I wanted to know. What was unique about this fact pattern that we gave you was that actually you were being asked, and this is why there was that important footnote, to engage in a process that actually wouldn't ever occur at the ICC because we were conflating, that means we were bringing together two parts of the proceedings that would never come together. You would never have one court, the trial chamber, looking at both the movement from preliminary examination to investigation and looking at individual liability in a case. We understood that when we were putting the fact pattern together. The reason we did that was to highlight this very unusual aspect of the International Criminal Court that is often confused. You'll hear it now when people are talking about the case against the Rohingya, involving the Rohingya, the case against Myanmar involving Bangladesh. There is no case right now. That's not where we're at. So the purpose of this, these kind of three questions, was with regard to the first question, we wanted you to really be focusing on this unique procedural element of moving from preliminary examination to investigation. And what's interesting, everyone looked properly at, Article 53 and that movement. If you look at the case law, the way it ends up hashing out is that often, and the way it's summarized kind of colloquially is that the court is going to be looking at jurisdiction, admissibility, and the interests of justice. So and that reasonable basis to believe that a crime has occurred ends up confusing a lot of people, because at this stage in the process with the preliminary examination, there should not be delving into the merits. You're meeting an incredibly low threshold, which is basically met by the assertion of there being murders or their assertion of there being a deportation. And that the critical element of that 53(1)(a) is jurisdiction. Is the court authorized? So that, and you would only see that when you look at the case law and you see how that's been played out, right? So I wanted to highlight that, that really, and it's, again, this isn't something that was going to be easy. We knew it was going to be a challenge. The reason we brought it to you was because this is so confusing for so many people. And let's say that those, and then when you're looking at the elements, it's jurisdiction, is the court authorized? Here it was clear because Zenjic was a signatory to the Rome Statute. So basically and temporally it fell at the right time. So you had jurisdiction. Admissibility, that's the point where you argue around the complementarity. I felt like that, that was that nuanced argument about, have they brought it? Can they, should they? And then the last one was the interests of justice. And recently there's been some delving into that with the Afghanistan case and the case law there. But that remains a big open question around interpretation. So, and all the while, at this stage, from the preliminary examination to the investigation, we are not talking about individuals. We're talking about the situation on the ground. So it's looking very broadly at what has occurred. And it's only once you're engaged, the Office of the Prosecutor has gone through the investigation. Oh, sorry. It's only when you go through the Office of the Prosecutor goes through the investigation that they then identify individuals to bring cases against. And that's when it moves, once a charging document is filed, or an arrest warrant is filed, that's when you start to have the creation of individual cases. But all the while, you still have the situation being investigated and looked into. So, and then you also have individual cases. So it's confusing, in this 5 minutes, we can't necessarily go over it. And, it may still be very fuzzy and muddled, but the important thing to look at or to know is just that preliminary examination to investigation is about a situation generally, and you're not really looking at your individual culpability, and you're not really looking at the merits. You're looking at jurisdiction, provision, procedural matters, and this amorphous interest of justice. So that was one thing I really wanted to know.
If I may draw a parallel on this. So very similar to what Nicole is saying in terms of whether or not a situation must be investigated, even when you argue individual criminal responsibility and you argue the elements, there are always these chapeau elements, right? These elements of setting the context. Is it an international armed conflict, or is it widespread and systematic? And I think even there, we have this conflation between whether or not we're looking at an individual or a situation in general. And I think that mistake is being made time and again by both parties. And yeah, one more place where we need to be careful whether we're looking at an individual or at the situation.
Yeah, and I think that's a fantastic transition to the next part that I wanted to talk about, which was about this idea that, when we were looking at the crimes against humanity and the war crimes, exactly that, you have the chapeau elements, which are also, you can think of them as, often when we talk about establishing these crimes, we talk about establishing the crime base and then establishing the linkage to the individual that we're prosecuting. So when we are establishing the crime base, for example, with a crime against humanity of murder, if it's being charged as a crime against humanity, so you have to establish widespread or systematic attack directed against a civilian population, right? And then you have to establish murder, because if you look at the definition, right, it's certain acts. So you have to establish some type of certain act. In this case, many of you chose murder, right? So you have to establish some certain act, and then widespread or systematic attack, and also then directed against a civilian population. But that's just the crime base. And now the layer on top of it is the responsibility of the individual that you have on trial. And that's the linkage to that individual. And that's where there was a fair amount of confusion, because you could have an individual that was actually a high-level perpetrator. Sometimes we have this, where that individual is actually present at a killing site and may even commit the killing himself, shoot someone, or more often we see it with raping someone or other types of torturing someone, those types of crimes. So there may be true direct perpetration, but now we're transitioning into that discussion of mode of liability. And you have a direct act that someone can be engaged in that way of actually pulling the trigger. But then you also have your command responsibility. And under that, you can think of having almost two branches. One, where the act, by virtue of that person's responsibility, flows to the commander. But then you also have the prevent or punish rather, right? So here, that's why we were asking some of those questions about that, because there was a lot of conflating around that liability. And I have to say, this is one of the most confusing aspects of international criminal prosecution, are these modes of liability. And especially once you start with, when you really dig into it, you'll hear the joint criminal enterprise discussion. You'll have, so it really becomes complicated very quickly. It's not a problem that people weren't quite on top of it, but what I really wanted to hone in on was the distinction between the crime base and establishing the crime base and establishing your linkage to your particular individual, okay? And then the other thing I wanted to know about with regard to these particular crimes was that I actually, as your judge, made a mistake. And it was only corrected during the defense stage. And this happens often, actually, when we're in court, that a judge will overlook something or be off in some way. And my mistake was that I wasn't appreciating that you were limited to that particular crime of a war crime. I had thought that you had received the citation to the whole crime against humanity section. That's why I was asking the questions about an international armed conflict versus a national or a domestic, internal armed conflict. Yep. And as a matter of international law, war crimes can be committed in either international armed conflict or internal domestic conflict. But you, in this fact pattern, were limited, and you were limited to international armed conflict. So the uncomfortable thing that you have to do is to tell a judge like me, who's not quite on it, that, we're limited to an international armed conflict. Now you should still be answering, oh, you're right, Your Honor. In fact, war crimes can be, either, internal or international in character. But in this instance, the prosecution has decided only to prosecute on this one narrow basis where they do have to show it's international. And if you're the defense in that instance, then you get to try to rip apart the international claim, right? The international armed conflict part. And if you're the prosecution, you have the added burden of showing international armed conflict. So I wanted to highlight that because I was really, especially in the first session, I was very confused because the preceding portion about crimes against humanity was about murder, the much easier bases for war crimes to establish. So one, my apologies for a bit of misdirection there, but also in some ways, you had a true real life experience here And ultimately did get corrected, but I wanted to highlight that as well. And then the other thing I would just flag is completely something as the American outsider coming to this, who has, I have practiced before the International Criminal Tribunal for the former Yugoslavia, so I'm aware of their procedures in the courtroom. I think in Bangladesh, generally, the courtroom procedure is more formal. And you ask leave to even just begin speaking, and that is not actually how it happens at the court, at the International Criminal Court, and certainly not in the U.S. courts or a lot of other common law courts. You just get to proceed ahead. So that's why there was often a pretty hefty pause on my part, and I was appreciative of my colleagues who were stepping in when I was not taking the role that I think normally a presiding judge would take in Bangladesh of saying proceed, and because that's not common in where I practice, and it actually is a little, it's less common. Some counsel do it before the International Criminal Court, but it's not expected on the part by the judges that you do that. So just so you know, you do have a heightened level of formality in Bangladesh, I think, than elsewhere.
I think it's a regional quirk. It's true in many countries in the area.
Yeah.
In practice, we're not that much of formal, but since they are learning, so they are now following each and every procedure. Mm-hmm. But in real court, where we practice, we're not that much formal, but we have a limited form of formal behavior. But since they are the law students, they are coming into the practice, so they are practicing everything.
Level of formality. Yes,
exactly.
No, that's great, and I appreciate it. And you did all do very well in asking for leave to continue speaking. So, yeah. Good job.
If I may, I just want to make a couple style points for those who spoke this evening. One, I think one thing that immediately is a red flag for me while listening to proceedings is, especially the use of pronouns. Like if you say they did this, they're doing this, they're saying this. Once again, it's about formality, but it's as far as I know, it's common practice, and it's highly preferable that you use third-person pronouns. Always refer to each party by their name, the prosecution, the defense. It helps the judges understand who you're referring to. It keeps the discussion formal. Also elevates your speech, right? It makes you sound better. So yeah, that's one point that I want to flag. That's it.
So thank you for staying a little longer. I just really wanted it. I felt like it would be a missed opportunity if we didn't try to clarify and also explain a little bit as to why we took this unusual approach to the fact pattern, having you have to deal with both these preliminary issues and criminal liability. But I hope it was a positive experience for you to go through this, and I hope you all now will also relax and and enjoy the evening. So I'll turn it back over to our coordinators. Thank you very much.
Much obliged, Your Excellencies. Participants are requested to leave the courtroom and join with us at the closing ceremony through same link at 6:45 p.m. Bangladesh time. Thank you.
Thank you, Nicole. Thank you, sir. Thank you, Shaklan, sir. Thank you.
Thank you.
Thank
so
you,
we are
Prakat
coming
Khati,
back
sir.
again on.
Yes,
we are
sir.
coming back
Yes.
again on 7.
7, yes.
And Shanchi, we just
Yep.
emailed you, or these our scoring, or how would you like to receive our scoring?
Yes. If you would just want to mail us, it's through mail.
Would you like a separate judgment sheet for each round, or would you like all of that averaged in one sheet?
It's actually better to each round, as there is 2 rounds. Yeah.
Sure.
Thank you. Thank you, everyone. Yes, sir.
I have already sent my judgment score sheet to Nasreen.
Oh. Efficient, sir.
All right, I better get on it then.
Yeah, same. All right, take care. Thank you so much.
Yes.
Okay.
Thank you.
Thank you.
Thank you, sir.
Thank you so much.
See you all.
Thank you, Prakat, Nicole, Shaklan, hi. Thank you so much. But we want to see you after 1 hour at our closing ceremony.
Yes.
Hi, Prakat, are you here? Prakat?
I think he already left.
Yes.
Okay.
Just a few seconds back. He just left.
Okay. So we are going to see you again at 7 p.m. Nicole, are you joining?
Yes, yeah, I'll join.
Okay, thank you so much.
Thank you so
Shaklan
much.
Bhai, are you joining, right?
Yeah, I will.
Thank you so much. So goodbye for now. Thank you once again. It would be less if we just thank you, but we couldn't do better in this online platform. So see you again.
Yeah.
Goodbye.
Okay. Bye-bye.
Goodbye.